O Tribunal pretende ainda estender sua jurisdição a questões relacionadas com o objetivo original da CEDEAO, que é a integração económica da região. Isto vai abrir uma nova visão em sintonia com as preocupações contemporâneas e os desafios existenciais da comunidade oeste africana.
ECOWAS is more or less a customs union. If you look at the protocol on free movement, you understand free movement. You look at the ETLS, economic trade, the ECOWAS trade liberalization scheme. You look at the protocol on common external tariff. We properly achieve the status of a customs union as it were. But individuals don't have access. Non-state actors don't have access to the court in respect of those instruments, and that is the main challenge.
The objective is to make the people feel part of the court. The court belongs to them.
Hello test, hello test. Your Excellencies, ladies and gentlemen, good morning. For the purpose of our opening ceremony, you will be given headphones. Portuguese is channel 1, English channel 3, French channel 2. The headphones have been distributed. Kindly draw our attention if you don't have. They are coming down with it, please. Also, kindly remember to put your phones on silent mode. Kindly put your phones on silent mode. Thank you. Ladies and gentlemen, kindly stand to receive His Excellency Neves. Kindly please sit down. Your Excellency President Neves, President of Republic of Cabo Verde, Excellency President of Constitutional Court, Your Excellency President of Supreme Court, Your Excellency Madam Minister of Justice, Honorable Vice President, Vice President and Judges of ECOWAS Court, Honorable President of Supreme Court of their representatives, Excellency President of EBID, distinguished guests from Raoul Wallenberg Institute, ladies and gentlemen of the judiciary family of West Africa, professors and academics, ladies and gentlemen of West Africa bars here present, ladies and gentlemen, Chief of Cabo Verde Administration, members of Diplomatic Corps, directors and staff members, ECOWAS Court of Justice, members of the press, ladies and gentlemen, good morning, bonjour, bon dia. Our opening session will be comprised by speeches, cultural moment, and the opening address of His Excellency President Neves. I would like to start this program by tendering our unreserved apologies to our distinguished guests and participants that were held at Casablanca Airport for more than 2 days. And despite all, they made it to be here. Thank you very much. Just a few months back, Court of Justice ECOWAS was having an international conference in Lomé, Togo. Being the judicial organ of the Community Court does not stop the court of adding its voice to the regional integration process in West Africa that has started 47 years ago. It is with great pleasure that this year it has been decided that Cabo Verde will hold our conference. But before going into the main subject of the day, let us appreciate a moment of culture of Cabo Verde.
Olá, bom dia. Sejam bem-vindos. Governantes de Cabo Verde, responsável de nossa justiça, nós que força de nossa nação, nossa luta e luta vence sempre. Governantes de Cabo Verde, responsável de justiça, nós que força de nossa nação, nossa luta vence sempre. Governantes de Cabo Verde, responsável de justiça, nós que força de nossa nação, nossa luta e luta vence sempre. Governantes de Cabo Verde, responsável de justiça, nós que força de nossa nação, nossa luta vence sempre. Nós que força de nossa nação, nossa luta e luta vence sempre. Nós que força de nossa nação, nossa luta e luta vence sempre. Nós que força de nossa nação, nossa luta e luta vence sempre. É pra nossa luta, é pra nossa luta, é pra nossa luta. É pra nossa luta, mano tá vence, 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 mano tá vence. Mano tá vence, 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 mano tá vence. Obrigado. Já não creio, franho, não sei de onde. A nós é lá de berço, nação cabo-verdiano, cidade velha, Ribeira Grande de Santiago, não tenho orgulho de ser seu filho. Já não creio, franho, não sei de onde. Mas nós é lá de berço, nação cabo-verdiano, cidade velha, Ribeira Grande de Santiago, não tenho orgulho de ser seu filho. Já não creio, fanhão, não sei de onde. A nós é lá de berço, nação cabo-verdiano, cidade velha, Ribeira Grande de Santiago, não tenho orgulho de ser seu filho. Cidade velha, Ribeira Grande de Santiago, não tenho orgulho de ser seu filho. Cidade velha, Ribeira Grande de Santiago, não tenho orgulho de ser seu filho. Não tenho orgulho, não tenho orgulho, não tenho orgulho. Não tenho orgulho, orgulho, ai 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 orgulho, orgulhosa, 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 ai orgulho, tenho orgulho, ai orgulho, ai orgulho, tenho orgulho, ai orgulho, ai orgulho, tenho orgulho, ai orgulho, ai orgulho, tenho orgulho, ai orgulho. Tenho orgulho, ai orgulho, orgulhosa, orgulhosa, nossa cidade, ai cidade, ai a mãe, ai a mãe, ai a Obrigados.
May I can call on Professor Solomon Ibubra? Professor Solomon Ibubra. Madam Minister of Justice, please. Chief Justice, please. President Abid. Ladies and gentlemen, let us welcome on the stage President Neves, followed by President Edward Amako Asante. Kindly stand for hymno de ECOWAS and Cabo Verde. Thank you. Kindly allow me to invite for his welcome address on behalf of the Community Court of Justice, ECOWAS, His Lordship Edward Amako Asante, President of the Court.
Thank you very much. His Excellency, President of the Republic of Cape Verde, President of the National Assembly of Cape Verde, President of the Constitutional Court of Cape Verde, the President of the Supreme Court of Member States of Cape Verde, Ghana, Guinea-Bissau, and Sierra Leone, judges of the ECOWAS Court of Justice, Deputy Speaker of the Parliament of Cape Verde, Attorney General of Cape Verde, President of EBID, Presidents and Magistrates of the Magistrate Courts in Cape Verde, representative of Raoul Wallenberg, members of the Diplomatic Corps, directors and staff of ECOWAS Court of Justice, the press, ladies and gentlemen. Your Excellencies, it's my pleasure to warmly welcome the President of Cape Verde, His Excellency Jose Maria Neves, on behalf of the ECOWAS Court of Justice, to the opening ceremony of this international conference being hosted by the court in this beautiful metropolitan city of Praia. We are indeed delighted that despite your very busy schedule, you have agreed to personally attend this opening ceremony to declare the program open. May I seize this opportunity to welcome all our invited dignitaries here present, including the Chief Justices of Member States, Honorable Ministers, High Government officials, and members of the Judiciary of Member States and Cape Verde, heads of institutions of ECOWAS, Honorable Judges of the ECOWAS Court, President of Regional Courts and Supreme Courts, Vice Chancellor of the University, where we are now, heads of ECOWAS national offices, special representatives of ECOWAS President in Cape Verde, Your Excellencies, members of the Diplomatic Corps, presidents of African Bar and other bar associations, international development partners, members of the academia, our resource persons, members of the press, and our collaborators. Your Excellencies and distinguished guests, it is common knowledge that ECOWAS was established by the Lagos Treaty on 28th May 1975. As presently composed, ECOWAS consists of 15 member states in West Africa. The ECOWAS revised treaty, which replaced the initial treaty, was adopted in 1993. This revised treaty is the fundamental charter of ECOWAS and a roadmap for the economic community integration. Article 3 of the revised treaty provides, in the main, and I quote, aims of the community are to promote cooperation and integration, leading to the establishment of an economic union in West Africa in order to raise the living standards of its people and to maintain and enhance economic stability, foster relations among member states, and contribute to the progress and development of the African continent, unquote. These are indeed laudable objectives. We are proud to note that ECOWAS has recorded a lot of achievements as the leading regional economic community in Africa. The ECOWAS Court of Justice is the principal legal organ of the community and one of the key institutions of ECOWAS. The essential role of the court is to ensure the observance of law and justice in the interpretation and application of the treaty and the protocols and conventions annexed thereto, and to be seized with the responsibility of settling such disputes as may be referred to it in accordance with the provisions of the treaty or between member states inter se and institutions of the community. The 2005 Supplementary Protocol on the Court, which amended the initial 1991 Protocol on the Court, granted to the Court 4 mandates. These are the mandates as a community court with contentious and advisory jurisdictions, mandate as an ECOWAS public servant court, mandate as an arbitration tribunal, and mandate as a human rights court. The importance of this international conference cannot be overemphasized because For the first time, an ECOWAS institution is providing a forum for a comprehensive review of the legal and institutional architecture for a regional integration project and the legal implications of regionalism, sovereignty, and supranationalism. The conference will pay particular attention to the existing legal framework for the ECOWAS integration project, and especially on what needs to be done to strengthen the existing legal and institutional architecture. The legal framework in most regional integration systems usually implies the direct applicability of community norms in the member states and the rights of community citizens to invoke community norms before the national courts of the integrating member states. The conference will therefore have the opportunity to place on the front burner the essential issues in the establishment of the functional legal framework in a regional integration arrangement and the shortcomings and challenges in the ECOWAS integration legal framework model. Your Excellencies, it is noteworthy that since the establishment of ECOWAS in 1975, it has adopted and implemented important legal texts, including the Protocol on ECOWAS Trade Liberalization Scheme, the Protocol on Free Movement of Persons, the Protocol on Democracy and Good Governance, among many others. We are, however, convinced that there are gaps in the legal framework of the ECOWAS integration project, and it's absolutely necessary to focus attention on these legal issues with a view to strengthening the existing legal framework of the ECOWAS integration project. By this, we are attempting to align our community objectives with the prerequisite legal architecture that is necessary for the attainment of our community objectives. The European Union remains a model for regional economic integration, and we may do well to learn from the established legal framework of the European integration project. The formation of a regional economic community is treaty-based. It is therefore of utmost importance to provide the enabling legal environment for the attainment of the community objectives. However, it takes more than the normative framework. It does not suffice to merely have a strong legal regime without an identifiable community legal order. Furthermore, the importance of a strong and independent regional court with treaty supervision and oversight functions to facilitate the integration project cannot be overemphasized. The theme for this conference is ECOWAS integration model, the legal implications of regionalism, sovereignty, and supranationalism. The intention of the court in choosing this theme is to focus attention on the essential ingredients of the legal framework for a regional integration arrangement, but with particular attention on the ECOWAS integration model and the legal implications of regionalism, sovereignty, and supranationalism. We cannot provide the enabling legal environment for the ECOWAS regional integration agenda without establishing a functional legal order that will ensure the attainment of our community objectives. A community legal order is the fulcrum of any legal integration arrangement. In order to effectively discuss all the ramifications of the theme of this conference, it has been divided into 7 sub-themes as indicated and listed in the brochure. The importance of this conference is mainly due to the fact that the themes and sub-themes are linked to the regional economic integration objectives of the community and the legal framework for the achievement of the community objectives. They are also relevant to the mandates of the various ECOWAS institutions. They also mainstream the role of the member states in the integration arrangement and the legal relationship between the member states and ECOWAS. We are delighted that we have an array of highly distinguished panelists consisting of legal experts, jurists, and professors of law who have been carefully chosen to discuss these issues because of their expertise and wealth of experience. We recognize that the member states are most important stakeholders in the integration process. We also recognize that the political will of the member states is a necessary factor for the achievement of our community objectives. It is also not in doubt that all member states are sovereign states. However, we cannot disregard the legal implications of supranationality of ECOWAS especially in the context of the powers given to ECOWAS by member states to act on their behalf in certain spheres. We have therefore invited stakeholders from member states to participate in this international conference because the integration process revolves around member states. Your Excellencies, though ECOWAS remains a pacesetter among regional economic communities in Africa, there are several constraints that are militating against the attainment of the community objectives. One of the key constraints is the lack of a functional community legal order that highlights the legal relationship between the member states and ECOWAS institutions and between the ECOWAS Court of Justice and the courts of the national member states. Similarly, although the ECOWAS Court of Justice is a pacesetter among regional courts in Africa, there are factors that are militating against the court in the discharge of its mandate, some of which pose existential threat to the court. Your Excellencies, permit me to highlight a few of these constraints. The reduction of the number of judges of the court from 7 as provided in the initial protocol on the court to 5 in 2018 is a grave concern to us, and it is having an adverse effect on the operations of the court. Despite the best efforts of the current set of judges, the number of cases pending before the court continues to grow astronomically. In the light of the increasing caseload of the court, it is obvious that a court composed of only 5 members cannot cope. It is also difficult to form more than one chamber in the court, since a chamber requires a minimum of 3 judges. It is therefore suggested that member states should consider restoring the composition of the court to 7 members as provided in the initial protocol on the court as soon as it is possible. Secondly, the reduction of the tenure of judges from 5 years renewable to 4 years non-renewable is also not in the interest of the court or the community, as there is no international court or tribunal that has such an abridged tenure for its judges. It is not advisable to model the tenure of judges of the court in line with the tenure of the commissioners of the commission, who are political appointees. There is no regional economic community that has this model. Furthermore, the complete renewal of the membership of the court, as was done in 2014 and 2018, as opposed to the staggered nature of the tenure of the judges, as envisaged under the initial protocol, is also not in the interest of the court and the community, as it leads to complete loss of institutional memory. Your Excellencies, the poor rate of compliance with judgments of the courts, which currently stands at about 30%, is also of great concern to the court. We regret that only 6 member states have appointed the competent national authority for the enforcement of the judgments of the courts. These are the republics of Guinea, Nigeria, Mali, Burkina Faso, Togo, and Ghana. We will continue to appeal for the remaining member states to do so and to do the needful. And I hope that this conference here in Cape Verde will result in the appointment of a competent national authority by our host nation, as was done by Ghana at its international conference in 2019. Your Excellencies and all distinguished participants, in conclusion, may I once more express the profound appreciation of the court to the President of Cape Verde for graciously honoring us with his presence at this opening ceremony. May I also express our profound appreciation to the government of Cape Verde for accepting our request to host this conference here in Praia, and for the African brotherly hospitality that has been extended to all non-resident participants at this conference since our arrival in Praia. May I also express our gratitude to the Chief Justices and Judges of member states here present, honorable ministers, high government officials, the Republic of Cape Verde, and all distinguished participants at this conference for accepting to be part of this very important conference. May I also express our special gratitude to the Raoul Wallenberg Institute on Human Rights and Humanitarian Law, for collaborating with us in hosting this conference. I am delighted that this conference gives us the opportunity to interrogate very important legal issues necessary for the establishment of a functional legal structure for the integration of our community. By the quality of the participants at this conference, and having had the privilege of reading through the papers to be presented by the resource persons in respect of the various thematic areas in the next 3 days. I am confident that this conference will be very fruitful and that the outcome will be useful in charting the functional community legal order for ECOWAS integration agenda in the years to come. I wish you all fruitful deliberations. Muito obrigado. Merci beaucoup. Thank you very much.
Thank you, President Asante, for a well-articulated message. Interinstitutional relations are key within the community, and leaders of our sister institutions always made it possible to participate in our programs. It is my pleasure to invite on this podium His Excellency Dr. Ajekum, President of ECOWAS Bank of Development, all the way from Lomé.
Good morning, distinguished ladies and gentlemen. His Excellency Jose Maria Neves, President of the Republic of Cabo Verde, Justices of the Supreme Court, Chief Justices of all member states herein gathered, distinguished legal luminaries, professors of law academia, heads of ECOWAS institutions, my lords, justices of the ECOWAS Court of Justice, members of the press, distinguished ladies and gentlemen, permit me to stand on existing protocol. We from the ECOWAS Bank for Investment and Development, which is the financial arm of ECOWAS, we are located in the Republic of Togo, Lomé. And for purpose of this function, I would just want to talk briefly about ECOWAS Bank for Investment and Development, because it appears that many of us are not aware of the existence of the bank. The bank was established at the same time when the ECOWAS Treaty was also passed in 1975. In 1979, the bank became operational. Since 1979, it has operated as a bank. It is owned by the 15 ECOWAS member countries, and that is the financial arm of the ECOWAS Community of West African States. The bank, as of today, has committed over $3.2 billion in the various sectors of the economies of West Africa. In Cabo Verde, Your Excellency, we finance the VIP lounge of the airport, of the international airport. We finance a number of ports also at the Sar Island. And recently, we extended the line of credit also to Novo Banco for on lending to SMEs. So just to let you know what the bank stands for before I give my speech. Thank you very much. It is an honor to address this August gathering in commemoration of the international conference hosted by the ECOWAS Court of Justice to discuss the legal climate in our community under the theme, ECOWAS Integration Model, the legal implication of regionalism, sovereignty, and supranationalism. Distinguished ladies and gentlemen, as the Regional Development Finance Institution, that is ECOWAS, providing financing solutions for both public and private sectors in member states, EBIT is too familiar with all the legal challenges posed by doing business across the countries. For instance, it has been difficult historically to coordinate enforcement of judgments against debtors operating in multiple jurisdictions. This is further compounded by the unwillingness of some local authorities to apply principles espoused by the Community Court of Justice. Your Excellency, permit me to digress a little. We from the ECOWAS Bank for Investment and Development, we obtain judgment against a member country about 3 years ago. Up to now, we haven't been able to enforce the judgment. These are the challenges that we have in the sub-region. And therefore, I consider this forum very, very, very critical and timely. Although EBIT maneuvers within the confines of the existing legal framework, with assistance of well-vetted local counsel for loan recovery purposes, the gaps in the general legal infrastructure adversely impact the sub-region's ability to attract investment. Regional economic integration would not be successful unless measures are implemented to give companies, especially small and medium-scale enterprises, a modicum of predictability and certainty when entering into international transactions, which can then be factored into costs and reflected in pricing. The legal framework rests at the core of business risk calculations, making it a key factor in the success of business initiatives and a long-term economic growth, and it's imperative that we develop solutions to the issues that plague it. I therefore call on all stakeholders at this forum to consider the following during discussions. 1, framing treaties and existing protocols as tools to fast-track regional integration, especially amidst efforts to promote trade within the framework of the African Continental Free Trade Area. Number 2, championing initiatives that further incentivize countries to refer cases to the committee court, especially those involving international plaintiffs. Number 3, concretization of efforts to equip local courts to enforce judgment by the ECOWAS Court of Justice through legislations in the various jurisdictions across the ECOWAS member state. As a lawyer myself, I'm cognizant of the influence of national cultures and belief systems on the legislature and in the evolution of the judicial framework, which justifiably generate hesitance to adhere to universalized norms that may not take countries' specific nuances into account. However, having seen the successes chalked by the European Union, not only in terms of facilitating free movement of goods and persons, but also as a negotiating bloc, we should be more persuaded of the value of supranational policies and structures. Permit me, ladies and gentlemen, to close by summarizing the objectives of the ECOWAS committee, the objectives of the community, as already alluded to by the President of the ECOWAS Court of Justice. Article 3 states, and I quote, to promote cooperation, integration, in order to raise the living standards of the peoples and contribute to the progress and development of the African continent, unquote. It is my hope that by focusing on our aims for the community, we will be able to resolve the issues confronting the legal environment. Looking at the credentials of the resource persons and all the other invitees, I have no doubt that this forum will provide a good basis for us to address the challenges that confront our legal environment as a community. On this note, I wish all of us very, very fruitful deliberations. Merci beaucoup pour votre attention. Thank you for your attention. Muito obrigado.
She is the co-host of this event. Kindly allow me to invite Senora Minister of Justice for her address.
Bom dia, Senhor Presidente da República, Excelência, Senhor Vice-Presidente da Assembleia Nacional, em representação do Senhor Presidente da Assembleia Nacional, Excelência, Senhor Presidente do Tribunal Constitucional, Excelência, Senhor Presidente do Supremo Tribunal de Justiça de Cabo Verde, senhores Presidentes do Supremo Tribunal de Justiça do Ghana, da Guiné-Bissau e da Serra Leoa, senhores Deputados da Nação, Senhor Procurador-Geral da República, Senhor Presidente do Conselho Superior da Magistratura Judicial, deputados aqui presentes, senhores representantes do Corpo Diplomático e organizações internacionais, senhor Provedor de Justiça, senhor Presidente do Conselho Superior do Ministério Público, senhoras da Comunicação Social, ilustres convidados, minhas senhoras e meus senhores. Permitam-me aproveitar esta oportunidade para saudar a todos os presentes e referenciar de maneira especial a presença do Sr. Presidente da República de Cabo Verde, Dr. José Maria Neves, que aceitou enaltecer esta cerimónia dela participando, num claro gesto de engajamento de todas as autoridades cabo-verdianas no aprofundamento da nossa integração na comunidade económica dos Estados da África Ocidental. Sendo membros de pleno direito desta comunidade desde 1976, é mister reconhecer que a verdadeira integração do nosso Estado, da nossa sub-região, nem sempre tem corrido de forma satisfatória. Efetivamente, entre altos e baixos, umas vezes mais ativos e outras nem tanto, creio ser consensual o reconhecimento de que ainda temos um caminho longo a percorrer e uma atividade diplomática importante a desenvolver, no sentido de uma integração engajada e proveitosa, tanto para Cabo Verde como para os restantes países da comunidade. Cabo Verde sempre soube das vantagens da nossa integração. Sempre soubemos que a nossa pequena dimensão territorial, populacional e económica pode ser altamente potenciada por uma comunidade prenhe de dinamismo, que se estende por mais de 5 milhões de quilómetros quadrados, conta com uma população de mais de 350 milhões de pessoas, com uma dimensão histórica, cultural, linguística e ecológica extremamente relevante no continente africano, com uma riqueza natural absolutamente destacável e um potencial de desenvolvimento político, económico e social assinaláveis. Por outro lado, temos consciência que, mesmo numa pequena dimensão, também podemos e devemos contribuir para o desenvolvimento de uma região que é nossa, que nos pode valorizar muito e que certamente também sairá reforçada com o contributo desta nação pequena em dimensão, mas grande de caráter, de cultura e de ambição. O caminho da nossa integração tem sido várias vezes dificultado pelas especificidades de Cabo Verde e pela circunstância de, não raras vezes, não termos os conhecimentos suficientes e bastantes para agir assertivamente. Devemos, contudo, reconhecer que há uma vontade genuína de acertar passos, um engajamento político mais intenso e uma representação institucional mais bem enquadrada. Temos procurado uma aproximação mais intensa com as instituições da CEDEAO, e esta conferência internacional, que está a ter lugar aqui na Praia, é um exemplo disso. Agradeço, pois, o Tribunal de Justiça da CEDEAO, ao seu presidente meritíssimo juiz Eduardo Assante, à nossa juíza Januária Costa e aos demais membros que escolheram Cabo Verde para realizar tão marcante evento, ciente de que será um sucesso e mais um instrumento de reforço da integração de Cabo Verde. Sejam, portanto, bem-vindos ao nosso país e aproveitem a oportunidade de convívio e a morabeza dos habitantes desta nossa acolhedora cidade da Praia. Senhor Presidente da República, Excelências, para Cabo Verde, a integração regional desejada é a mais ampla possível e deve realizar-se sempre considerando as especificidades territoriais, populacionais, económicas e culturais do país. A integração política e institucional é um desafio imediato. A nossa presença assídua e sistemática em todos os órgãos e organizações da CEDEAO, a participação efetiva nos processos de tomada de decisão, o preenchimento dos postos políticos e administrativos que nos cabem, aliados ao fortalecimento de relações bilaterais e de interesses, são fatores que melhorarão o desempenho de Cabo Verde neste quesito. Numa região tão rica e diversificada do ponto de vista histórico e cultural, com grandes potencialidades humanas a nível desportivo, torna-se imperativo o aproveitamento desses setores como oportunidades económicas de grande alcance que podem aproximar os povos, as instituições e os agentes e constituir-se em pilares fundamentais de integração regional e um forte instrumento de afirmação africana. As nossas relações comunitárias na vertente da justiça se desenvolvem naturalmente. O Tribunal de Justiça da CEDEAO, aqui presente na sua máxima expressão, tem mantido relações institucionais com a justiça cabo-verdiana. Tem seguido Cabo Verde e analisado a nossa situação judicial. Os caminhos da integração plena estão sendo trilhados. A nossa presença permanente nesta instituição é garantida, neste momento, por uma juíza e seu respectivo staff. A nossa cooperação e o nosso intercâmbio com as outras instâncias ligadas à justiça e à criminalidade na sub-região são permanentes. Sempre que necessário, o Tribunal de Justiça tem analisado questões relativas a Cabo Verde e tem produzido as suas dotas disposições, tendo sempre contado com a colaboração e envolvimento das autoridades jurisdicionais do país. Regularmente acolhemos ações de intercâmbio entre a realidade jurídica nacional e a comunitária, nos engajamos na eliminação das barreiras que ainda dificultam a nossa plena integração. O trabalho de casa vai sendo feito. Senhor Presidente da República, distintos participantes, minhas senhoras e meus senhores, a Conferência Internacional Modelo de Integração da CEDEAO, cuja abertura ora se procede, bem como o seu conteúdo específico, as implicações jurídicas do regionalismo, da soberania e do supranacionalismo, são oportunidades para discutirmos o nosso modelo de integração, a história política e as especificidades legais existentes na sub-região. Será momento de intercâmbio entre juristas, académicos, juriscônsulos e políticos, juntos numa jornada que se pretende de bons frutos e de convívio, onde certamente se aflorarão questões como objetivos e modelos da integração regional, os conflitos de direito entre os quadros legais nacionais e supranacionais, as formas de compatibilização normativa, os desafios e a agenda da integração económica regional, ou ainda as implicações da integração regional na defesa dos direitos humanos e da cidadania. Será uma discussão que nos fortalecerá e nos proporcionará a oportunidade para questionar o caminho já percorrido, os obstáculos vencidos e os ainda por ultrapassar. Pelos atores presentes, teremos apresentações e debates de alto nível. Aguardamos pelas conclusões, na esperança de as utilizar para elevar os níveis de eficácia da integração na CEDEAO. Mas esperamos também que das discussões, das análises comparadas que inevitavelmente serão feitas, surjam ideias específicas para um melhoramento do desempenho da justiça nos Estados-membros. Ideias que nos ajudarão a encarar muitos dos problemas com que nos deparamos neste momento, tais como a plena integração dos nossos cidadãos, a promoção e a proteção dos direitos humanos, a proteção dos empresários, das empresas e dos investimentos, a justiça comercial, administrativa e aduaneira, o combate à criminalidade organizada e à corrupção, só para dar alguns exemplos. Ideias que nos poderão ajudar na adoção de medidas comuns que reforcem a sintonia, a aproximação e a convergência normativas, que considero imprescindíveis no nosso processo de integração sub-regional. Fica assim perceptível que o Governo de Cabo Verde, e particularmente o Ministério da Justiça, que tem a responsabilidade de dirigir, entendem a importância desta conferência, encaram-na de forma positiva e anseiam por contributos. Por esta razão, desejo que os trabalhos decorram na normalidade e me disponibilizo para prestar todo o apoio ao meu alcance, proporcionando condições de sucesso para este que é um grande evento para o país. Obrigada a todos.
Merci, Madame la ministre de la Justice. Pendant quelques années, il a été membre de la Cour de justice de la communauté. Et c'est avec un grand plaisir que nous retrouvons aujourd'hui l'honorable juge Mosso Benfeito Ramos, président de la Cour suprême de Cabo Verde. Monsieur le Président, vous avez la parole.
Senhor Presidente da República, Excelência, Senhor Vice-Presidente da Assembleia Nacional, em representação do Senhor Presidente, Senhor Presidente do Tribunal Constitucional, Senhora Ministra da Justiça, Venerando Presidente do Tribunal de Justiça da CEDEAO, venerandos presidentes dos Supremos Tribunais dos países da CEDEAO aqui presentes, Senhor Presidente do Conselho Superior da Magistratura Judicial, Senhor Provedor de Justiça, distintos convidados, caros colegas magistrados, minhas senhoras, meus senhores. Constitui para mim uma grande honra poder usar da palavra nesta sessão de abertura da conferência organizada pelo Tribunal de Justiça da CEDEAO sobre as implicações jurídicas do processo de integração regional, para, em nome do Supremo Tribunal de Justiça, dos seus juízes conselheiros e dos demais magistrados judiciais de Cabo Verde, saudar a realização deste importante evento no nosso país. Embora a nossa jurisdição comunitária tenha realizado já algumas missões de sensibilização a Cabo Verde, esta é, porém, a primeira vez que essa instituição, na qual tem estado a servir uma das nossas proeminentes magistradas, a excelentíssima juíza Januária Costa, a quem aproveito para saudar vivamente, dizia que é a primeira vez que o Tribunal da CEDEAO distingue o nosso país com um fórum de tamanha envergadura, reunindo juristas, académicos, profissionais do foro e outros peritos de elevadíssima craveira, para uma reflexão conjunta sobre o processo de integração regional e as questões mais candentes que o mesmo vai suscitando. Regozijo-me, pois, por ver a nossa cidade da praia ser erigida durante estes dias na capital do direito e da justiça da CEDEAO. Por isso mesmo, queria dar as boas-vindas a todos que se deslocaram dos diversos países da nossa comunidade para virem partilhar conosco o seu saber, as suas ricas experiências e perspectivas sobre como promover a integração regional em termos que possam incorporar valores incorporar efetivos benefícios para os nossos países e os nossos povos. Peço, entretanto, a vossa licença para a minha qualidade de Presidente do Supremo Tribunal de Justiça de Cabo Verde, em substituição, associar o meu passado de juiz do Tribunal de Justiça da CEDEAO, no qual tive o privilégio de servir como vice-presidente por mais de 5 anos. Prevalecendo-me de tal estatuto, não posso deixar de partilhar a minha enorme satisfação em rever muita gente conhecida, muitos amigos, sejam eles funcionários do tribunal, advogados, professores e tantos quadros da nossa instituição comunitária com quem tive o privilégio de trabalhar muito de perto no passado. Gostaria de dizer a todos que guardo gratas lembranças das nossas lides e da minha passagem como juiz e funcionário estatutário da CEDEAO. Pude desfrutar de uma interação fecunda, sendo certo que essa foi das mais ricas experiências que vivi. O jurista que sou hoje, servindo na mais alta instância judicial da República de Cabo Verde, deve muito àquilo que aprendi convosco no plano profissional, em que pude alargar imensamente os meus horizontes, particularmente em sede do direito internacional, com uma profunda imersão nas influências de outras famílias jurídicas, em especial da Common Law. Mas pude também beneficiar da excelência das relações humanas, marcadas por uma enorme fraternidade e por uma firme convergência na construção da nossa comunidade. Por isso gostaria, caros amigos, que se sentissem em Cabo Verde como sempre eu me senti em Abuja, em Dakar, em Bissau, em Ouagadougou, em Bamako, em Abidjan ou em qualquer das capitais dos países que integram a nossa rica e diversificada comunidade. Senhor Presidente da República, Excelência, distintos convidados, o percurso feito pelo Tribunal de Justiça da CEDEAO é assinalável. Começou a ser sedimentado, como muitos hão de confirmar, com a histórica decisão proferida no caso Adijatu Manikurau contra a República do Níger, de que ouvi falar em Cabo Verde ainda antes de me juntar ao tribunal. Vieram depois outras decisões marcantes que cativaram a atenção da comunidade jurídica e da academia, mesmo fora de África. Ousaria afirmar que o Tribunal de Justiça chegou a um patamar de irreversibilidade, de não retorno, no sentido de que já não será possível conceber a CEDEAO sem essa sua instituição emblemática, que, de uma existência incipiente e claudicante, acabou por se impor pelo seu crescente papel na garantia dos direitos do homem na nossa sub-região, erigindo-se como uma referência em África e objeto de reflexão por académicos de outras partes do mundo. Sinto-me profundamente honrado e reconfortado por fazer parte desse percurso. Por isso mesmo, e falando em certa medida com conhecimento de causa, posso afirmar, sem receio de errar, que um dos traços mais marcantes do Tribunal de Justiça da CEDEAO tem sido a sua capacidade de olhar para a realidade, com agudo sentido crítico, de modo a apreender em todas as suas dimensões e na sua densa complexidade os desafios com que se defronta em cada momento e encontrar as melhores soluções para os ultrapassar. Numa palavra, e se tal me é permitido, diria que o segredo do Tribunal de Justiça da CEDEAO tem residido na sua capacidade de antever cenários e ajustar a sua estratégia de progressiva afirmação a tais cenários. Neste sentido, permitam-me partilhar um testemunho. Há alguns anos, logo depois de ter cessado as funções no Tribunal de Justiça da CEDEAO, tive o privilégio de participar com o professor Solomon Ebobra, presente aqui entre nós, numa conferência em Florença, na Itália, em que um dos aspectos que foram enaltecidos foi precisamente a razoabilidade, a sagesse e a prudência das decisões do nosso tribunal, por contraposição com outras jurisdições congêneres, cujos pronunciamentos, por deficiente percepção da realidade, tinham conduzido primeiro a uma crise existencial e, finalmente, ao colapso. Por isso mesmo, é-nos exigido lançar um olhar mais alargado, um olhar que não pode dispensar o realismo sobre as dificuldades que se têm colocado às jurisdições dos direitos do homem em África, seja a nível subregional, seja a nível continental, neste caso no quadro do Tribunal Africano dos Direitos do Homem e dos Povos. Com a sociologia jurídica, aprendemos que existe uma enorme distância entre law in books and law in action. Trata-se de um desfazamento que é devido, em grande parte, à inadequação dos textos jurídicos à realidade a que se pretendem aplicar. Nesse aspecto, a experiência comparada não pode deixar de ser convocada como um precioso instrumento de análise para nos ajudar a compreender o percurso feito por outros, mas também para nos ajudar a prevenir e a evitar erros que terão sido igualmente cometidos por outros. Sobretudo, importa compreender por que algumas experiências acabaram por ser bem-sucedidas. O caso do Tribunal Europeu dos Direitos do Homem, no quadro do Conselho da Europa, parece ser paradigmático, ao passo que outras falharam ou tendem a falhar. No caso que nos interessa de modo muito particular, que é o quadro africano, por que algumas jurisdições dos direitos do homem têm sobrevivido e outras não? Estou certo de que o fórum a que ora damos início irá contribuir substancialmente para encontrarmos as respostas que procuramos. Pela nossa parte, vamos desde já deixando a nossa modesta opinião de que o processo de integração regional, em todas as suas dimensões, e no que diz respeito à justiça em particular, só poderá ser bem-sucedido se for comunitariamente consensualizado, isto é, se puder conquistar a natural adesão dos cidadãos, dos agentes económicos, da academia, das elites e das demais forças vivas dos nossos países. Nesse aspecto, há que ter presente que, como já ensinava Amílcar Cabral, o herói da luta pela independência da Guiné e de Cabo Verde, os povos não abraçam ideias abstratas, por mais bem elaboradas que elas possam se apresentar. Querem, sim, resultados concretos e palpáveis, que se traduzem na melhoria das suas condições de vida. Querem, numa palavra, uma razão para acreditar e para emprestar o seu apoio legitimador ao projeto de integração regional nas suas diversas dimensões. Eis, pois, o grande desafio que se coloca a todos que militam em prol da integração regional em África, e em especial na nossa sub-região. Persuadir os nossos povos, convencer o cidadão comum, o homem da rua, de que desse processo resultarão vantagens mútuas para os países, mas também para as suas gentes. Estou seguro de que conseguiremos concretizar tal desiderato. É com esta convicção que concluo esta breve intervenção, renovando os meus votos de resultados muito profícuos para a nossa conferência. E já agora, votos também de uma boa estadia em Cabo Verde. Muito obrigado.
Merci, Monsieur le Président de la Cour suprême. Le thème qui a été choisi a été vu et relu par un académicien présent en ces lieux. Il me revient donc d'inviter le professeur Solomon Ebobra à nous donner son point de vue sur le thème de cette conférence.
Your Excellency, the President of the Republic of Cape Verde, Your Excellency, the President of the ECOWAS Court, Excellencies, Your Lordships, ladies and gentlemen, please permit me to stand on the existing protocol. First, I'd like to apologize. I have a 26-page paper that I'm sure that I'd not be able to read through here, so you'll permit me to just speak to the paper and then probably would have the time to engage afterwards. Having said that, I'd like to sincerely express my profound gratitude to the President of the ECOWAS Court and to the organizers of the conference for giving me the opportunity, very rare privilege, to address this august gathering. I think my task is perhaps both a difficult and a straightforward one, to set the pace for our conversation at this conference. And I'm able to say that there are just two aspects to the theme that I think I would like to engage. The one is perhaps a controversial one. Do we really have an ECOWAS model of integration? The other one, which is usually more interesting to everyone, but I think is less controversial, is the legal implications of what we do in ECOWAS. I think over time, we've been tempted to think that the ECOWAS has a model, and that model is fashioned after the European Union model. And therefore, as a logical consequence of that model, there are legal implications, particularly arising out of supranationality or supranationalism. And I think perhaps we need to take a step back to reinterrogate that assumption. Do we really have an ECOWAS model? Is that model really in the image of the European Union? Is there supranationalism in the ECOWAS framework? Perhaps also a bit less controversial, but equally controversial, is the question whether the legal obligations of ECOWAS member states are higher when we lift ECOWAS to a level of supranationality or supranationalism, and then they reduce when we situate it within the frame of intergovernmentalism. I'm going to perhaps annoying you by saying that there is currently no ECOWAS model that is peculiar to ECOWAS. And my basis would be to say that the ECOWAS is currently an intergovernmental organization operating within the framework of international law as we know it. But then I'll argue that that does not reduce the legal obligations that member states have taken on by signing up to ECOWAS. But then I'll go a step further to perhaps push your mind to say that integration requires two parts. There's the market building aspects of integration, and there's the market regulating part of integration. So that the argument I make is that the market building aspect of integration requires intergovernmental actions, whereas the market regulating aspects of integration would require supranational actions. And the problem arises when, without creating or successfully creating a market, we seek to interpose supranationalism on a strictly ill-prepared organization. I've developed the argument in those 26 pages, as I've said, but I won't have all the time to say that. So I'm going to quickly rush through the main key points of my paper and hope that at a more convenient time, everyone would have the opportunity to look at it. So perhaps the first point I'd like to start with is to interrogate what really is integration. And the best place we go to check what integration is will probably be the European Union, because it's, some would argue, the most successful model of integration that we have. Now, the key points that I wanted to bring out from that European system is to say that if you look at the definitions that are given by scholars like Haas and maybe even Schmitter, you'd find that integration essentially involves the congregation of otherwise independent states that are usually geographical proximate in an organization. But essentially, it's a process. It's not an event. And then it usually involves some loss of sovereignty. Some loss of sovereignty. Now, Schmitter adds that if you look at the European model of integration, there is a creation of special institutions which then exercise authority to bind the member states, and if you push it a bit further, bind citizens of member states without necessarily passing through the processes of lawmaking within the national legal system. So I'd like you to hold on to those. But I'd like to then add that integration essentially begins as a fallout of interstate relationship within the framework of public international law, which then means that the rules of public international law, Pacta sunt servanda and the rest of them, apply to the relationship immediately states proceed into an organization like ECOWAS. Now, when you look at the European model of integration, there's some sort of dissatisfaction with the intergovernmental approach to integration that public international law offers. Therefore, you move a bit further to create institutions that then we call supranational institutions that you confer with authority to do certain things. So I'll quickly then refer you to Claude Jr., who says there are three main aspects to supranationalism. By the way, that supranationalism is what some people call the constitutionalization of integration within the European framework. So essentially, the first part involves what you might want to call the reduction of the decisional veto, so that within the framework of European integration, this thing that we have in public international law, where the state decides whether it wants to be part of a project, whether it wants to be bound by laws and all of that. In other words, the voluntariness that is critical in public international law is taken away. So that instead of unanimity in the decision-making process, you probably would have some sort of majority voting system. So the first criteria or the first character that you can extract from that is that decision-making is based on majority voting rather than unanimity. So it takes away the decisional veto that a state would have, because the state does not need to give it consent for the organization to take certain decisions. The second part would then be empowering organs or institutions of the created organization to exercise powers that bind member states, and in some cases this then becomes the third part, that would then pierce or penetrate the national legal system to have direct effect without any need for transformatory legislation within the national legal system. Now, essentially, the last two parts would then take away the normative veto that the states should have, which then means that the states would not be in a position to continue to play the gatekeeping role that they would play under public international law. So those three parts, those three features would then qualify integration to have moved from intergovernmentalism to supranationalism. So that then brings me to the question whether ECOWAS is a supranational organization. And I'm going to then suggest to you that if you look at the evolution of ECOWAS, there are three epochs that you can identify broadly. The first epoch is the epoch that I would situate within the context of the 1975 original Treaty of ECOWAS. And I'm sure it had been mentioned here that treaty, that treaty in Article 2 sets out the aims of ECOWAS, and it basically says ECOWAS is an organization for economic cooperation. It ends at that. Now, if you are fortunate to have come across the doctoral thesis of one of the founders of ECOWAS, General Yakubu Gowon, he was very clear that ECOWAS heads of state, the founding heads of state, most of whom were essentially military leaders, took the view that they were not willing to cede too much of their sovereignty to an organization. That was one. Now, the effect of this was that in the institutional build-up, the secretariat of the ECOWAS was exactly that. It was a secretariat to provide secretarial services to the organization, or basically to the heads of state. That epoch then, in my view, did not contemplate any loss of sovereignty, or if there was any loss of sovereignty, it was very minimal. It did not envisage that decision-making would take place at a level other than at the level of unanimity. Every state must be involved before a decision could be taken. One of the features then was also that the progress of ECOWAS dependent on the making and adoption and ratification of treaties in the form that we know it in public international law. Now, the second epoch, some would argue, began before the adoption of the 1993 revised treaty, resulting from all of the crises that we had in West Africa, the civil wars and all of that. But I would prefer to fix it within the context of the 1993 revised treaty. You would notice, if you looked at the preambles to the 1993 revised treaty, that there was some sort of organizational shift. So we saw a movement from ECOWAS aimed at economic cooperation only to cooperation and integration of ECOWAS. So that perhaps in recognition of that shift, member states also made a mental leap, because they then said they concede that integration, in order to be successful, would require some loss of sovereignty. Now, sovereignty does not necessarily mean that it's lost in the sea, but you concede sovereignty to the organization. However, that second epoch did not also make a major shift in terms of the nature of normative materials that ECOWAS was supposed to release. So we found ourselves still within the context of treaty making, treaty adoption, treaty ratification, which would then, in states that are dualist, require legislative intervention within the national legal system to have any effects of ECOWAS in the national legal system. But also importantly, while additional institutions were created that gave the impression that there was a shift towards supranationalism, including the transformation of the ECOWAS court from the tribunal of the community to the community court of justice, there was still some fixation on intergovernmentalism, because the court itself was essentially to interpret the treaty. But if perhaps you haven't noticed, you would also perhaps look in that, I think, Article 5 of the 95 treaty, and you would see that the heads of states were very careful to say none of the organs or institutions created by ECOWAS is allowed to exercise powers beyond what is expressly granted to them within the framework. So, you are not allowed to be activists. You are not allowed to push the boundaries beyond what is clearly stated. Now, the third epoch I would situate around 2006, where the supplementary protocol that amended the treaty was adopted. Not to bore you, Article 9 essentially shifted ECOWAS towards what would look like a supranational organization, because it said instead of continuing to adopt treaties, we would then move to the adoption of supplementary acts. But most importantly, those supplementary acts were supposed to have direct effect within member states. That's the language that was chosen. But beyond that, there was also a transformation of the ECOWAS Secretariat from the Secretariat to an ECOWAS Commission. All of this looked very nice on paper. When you look deeper, you would see that that transformation of the ECOWAS Secretariat into the ECOWAS Commission did not really come with any significant change, because the Commission remained the Secretariat. It could perform secretariat duties, it could service meetings of the heads of states and meetings of the ministers, but it did not have power to make law. It did not have power to make policies that would have effect beyond seeking to implement decisions of the heads of states and the ministers. So essentially, what you would recognize from these is that in this third epoch, the first part of this third epoch, ECOWAS heads of states retained supreme lawmaking powers. ECOWAS heads of states also made sure that there was no transfer of powers to any of the so-called supranational bodies of ECOWAS. But beyond that, it's also the fact that there was a pretense that we have moved into an era where you'll adopt treaty, you'll adopt acts, supplementary acts, but these acts were basically adopted based on unanimity. However, if unanimity was not possible, then there would be adoption by consensus. It is only in the very extreme cases that you would have a majority decision as a basis for the adoption of a supplementary act. Now, if you took a step back and went to the three features of supranationalism, you'd notice that the decisional veto was retained. There was an appearance of a conceding of the normative veto, so that states more or less were supposed to relax their gatekeeping role at the national level. But it's your guess whether that really happened. So what the ECOWAS then did, what ECOWAS heads of state then did, was that no single supplementary act with effect that threatened sovereignty was adopted. So you would find supplementary acts that are adopted to appoint people. You would find supplementary acts that were adopted to take on collective actions, but you'd never find any supplementary acts that were adopted with intention to have effect that more or less disturbed the supranational or the sovereignty of any particular state. Even before that would have been settled properly, another shift occurred within that third epoch. This was in 2010, when another supplementary act was adopted, reversing more or less some of the gains that had been made under the 2006 supplementary act. What it essentially did was to say the heads of state still retain the power to adopt supplementary acts, but those supplementary acts no longer had direct effect within the national legal system. Rather, it was said that member states undertake to ensure compliance with or implementation of the decision of these supplementary acts within the national legal system. So, essentially, we've had three epochs within the ECOWAS, in the evolution of ECOWAS. In all three epochs of the evolution of ECOWAS, member states have held on very strongly to decision-making powers. Now, at some point, we would notice that in the third epoch, there has been some sort of pooling of sovereignties. So, member states are willing to adopt certain instruments of ECOWAS based on majority lawmaking. So, sovereignty is shifted, but it is pooled together for member states to exercise collectively. It does not shift to any organization of any organs or institutions of ECOWAS. And it does not then penetrate the national legal system. So we are left more or less with an intergovernmental organization masquerading as a supranational organization. What then is the legal implications of all of this? Before I speak on the legal implications, I just wanted to say that if you look at the European model of integration, you would see that intergovernmentalism and supranationalism exists in a continuum of sort, so that where there was necessity to create the market, breaking down the obstacles within the national legal system, intergovernmental acts were invoked. So member states had to deal with their constitutional ghosts, if you like. Member states were the ones who had to deal with national parliaments. Member states were the ones who had to deal with the constitutional barriers that they faced. It wasn't the supranational organizations. Now, at the point where the market is successfully created, then it became difficult for member states to continue to hold on to the powers of coordination and all of that. So at that point, you needed the supranational act. And the regulation of the market that is so created then becomes a supranational function that was shifted to the organizations, the organs created within the organizations to do. Now, in the case of ECOWAS, because member states have not really been honest in their dismantling of the national barriers to the creation of an ECOWAS market, Penero would appear in Ghana and try to be part, to enter the Ghanaian bar in the name of ECOWAS, but there's really no market created there that allows him to come in. So he's met by the Ghanaian legal system and the Ghanaian obstacles. The ECOWAS court cannot help him. There's no ECOWAS market. So there's nothing to be regulated at a supranational level. So that becomes then the major obstacle, in my view, to the creation of a supranational organization. Because even if you create the organizations, there's no market that will be regulated. Now, just 1 minute and I'll be done. The legal implications are that sovereignty remains where they are. Sovereignty remains exactly with the member states. But does that mean that there are no obligations on the member states? No. We then fall back to the rules of public international law. And I'm sure everyone who is familiar with international law knows that if you adopt a protocol, if you ratify a protocol, then you take on legal responsibilities. The only difference is that while it cannot penetrate the national legal system to create obligations within the national courts, the member states have responsibility at international law. That's where the ECOWAS court continues to have its relevance. Thank you very much.
Thank you, Professor Solomon Ebobra. You will agree with me that having heard so much, we need some minutes of relaxation to digest everything. It is my pleasure to invite on this stage another face of the Cabo Verde culture, the single singer Arlindo, for a performance.
Bom dia, bonjour, and good morning. Welcome to the Cape Verde, the land of Morna, our patrimônio. Tenho o prazer de introduzir as Morna de Antero Simas. Obrigado à organização pelo convite também.
Oi,
Cabo Verde, boi ganhador, mas sublime. Oi, Cabo Verde, boi quem angústia minha paixão. Minha vida nasce de desafio de bucle ingrato. Vontade de ferro, pom na minha peito. Gosto pra luz, pra pôr nas minhas braços. Oi, quem é nós, minha doce amor. Oi, Cabo Verde, oi, quem é dor, mas sublime. Oi, Cabo Verde, oi, quem angústia minha paixão. Minha vida nasce de desafio de bucle ingrato. Vontade de ferro, pôr na minha peito. Gosto pra luta, pôr nas minhas braços. Oi, quem é guerra, minha doce amor. Estende os braços, vou tomar minha sangue, vou regar o chão, vou florir. Uma terra longe, bem acabar longe, um pouco mais seu e vos filhos, num doce abraço de paz. Naquele dia de festa, me crecolar, São João na Pico, um crebatu na Ribeira Julião. Vulcão na praia de Santa Maria, Val de Paú na Boa Vista, Orna e Eugênia e São Nicolau. Oi, Cabo Verde, oi, quem a dor mais sublime. Oi, Cabo Verde, oi, quem angústia minha paixão. Minha vida nasce de desafio de bucle ingrato. Vontade de ferro, pôr na minha peito. Gosto pra luta, pôr nas minhas braços. Oi, quem é guerra, minha doce amor. Estende os braços, vou tomar minha sangue, vou regar o chão, vou florir. Uma terra longe, bem acabar conosco, pouco mais seu e vos filhos, um doce abraço de paz. Naquele dia de festa, me crecolar, São João na Picos e um crebatu na Ribeira Julião. Vulcão na praia Santa Maria, Val de Paú na Boa Vista, Morna em Eugênia, em São Nicolau. Obrigado, merci, thank you. Muito obrigado, até a próxima.
Merci beaucoup. Nous voilà tous donc rafraîchis pour quelques instants encore. We are very grateful to him for accepting the court in Cabo Verde, following the decision of ECOWAS Court Management to organize this conference here in Cabo Verde. Tenho o prazer de convidar Sua Excelência, o Senhor Presidente Neves, para o discurso inicial.
Senhor Vice-Presidente da Assembleia Nacional, Senhor Presidente do Tribunal Constitucional, Senhor Presidente do Supremo Tribunal de Justiça, Senhor Presidente do Tribunal de Justiça da CEDEAO, Senhores Presidentes do Supremo Tribunal de Justiça do Ghana, da Guiné-Bissau e da Serra Leoa, Senhora Ministra da Justiça de Cabo Verde, senhoras e senhores deputados, Senhor Presidente do Conselho Superior da Magistratura Judicial, Senhor Provedor de Justiça, senhoras e senhores embaixadores e representantes dos organismos internacionais, senhoras e senhores magistrados, senhoras e senhores diplomatas, senhoras e senhores professores e estudantes, senhoras e senhores jornalistas, convidadas, convidados, minhas senhoras e meus senhores. Em primeiro lugar, para agradecer o grupo de batuque de Nozerance, da Cidade Velha, de agradecer o Arlindo Rodrigues por este hino a Cabo Verde e também agradecer o ilustre professor Dr. Salomão Ebobra pelas suas elucidativas palavras sobre a integração e os supranacionalismos. Saúdo todos os presentes, mas de forma muito especial as senhoras e os senhores integrantes da delegação do Tribunal de Justiça da CEDEAO, a quem desejo uma excelente estada no nosso país. Agradeço o honroso convite que recebi para presidir a esta cerimónia de abertura da Conferência Internacional do Tribunal de Justiça da CEDEAO. Considero que este evento é de grande relevância e espero que estes 4 dias de trabalho sejam muito produtivos e que sejam alcançados todos os objetivos preconizados. É sempre com grande alegria que Cabo Verde acolhe encontros desta natureza e envergadura, promovidos pela CEDEAO e este em particular, sempre na expectativa de que se tornem mais rotineiras. Temos sempre enorme prazer e honra em receber os irmãos da nossa sub-região e, como sempre, queremos continuar a ser úteis e contribuir para o crescimento institucional da nossa comunidade e para o reforço da integração regional em todas as suas dimensões. A integração regional é uma opção fundamental do Estado de Cabo Verde e um eixo definidor da nossa ação no plano externo e igualmente no plano interno, pelas suas consequências para a formação de políticas públicas nacionais. Realço que na nossa sub-região, Cabo Verde é o único Estado insular de mais reduzida população e superfície, carente de recursos naturais tradicionais e extremamente vulnerável e sensível a choques externos, tanto no domínio econômico-financeiro, como no tocante às questões climáticas e ambientais. Tais condições, por si sós, tornam mais exigente todo o nosso trabalho em ordem a uma plena integração na região. Longe de nos desanimar, esses condicionalismos estimulam-nos a persistir na defesa de um estatuto específico que nos permita estar mais próximos, cada vez mais em sintonia com as dinâmicas da integração, para elas contribuindo e delas beneficiando legitimamente. No outro sentido da mesma estrada, é fundamental que a comunidade entenda esta nossa insularidade como uma sua riqueza e um fator propiciador de maior aproximação com outros espaços geoeconômicos, bem como de diálogos e parcerias estratégicos que tenham em vista o Atlântico como um corredor de paz, segurança e desenvolvimento. Da mesma forma que não há desenvolvimento sem paz e estabilidade, também não é razoável pretender um contexto duradouro e sustentável das problemáticas de segurança e estabilidade na nossa região sem uma correta compreensão e inserção dos desafios em matéria de segurança marítima e de manutenção da legalidade em todo este quadrante do Atlântico. Neste equilíbrio de fatores, revela-se essencial entender devidamente a posição geoestratégica de Cabo Verde e todo o contributo que ao longo dos anos e a despeito da sua pequenez tem dado para a melhor gestão de desafios globais aqui neste cruzamento crucial para a política e a governação internacionais. Uma forte aposta na conectividade com este arquipélago, conectividade aérea, marítima, de negócios, de fluxos tecnológicos e de conhecimento, deveria ser defendida e promovida por todos, tal a sua relevância para a comunidade pujante e inclusiva que queremos. A CDAO não pode descurar as suas autoestradas de progresso e inclusão no e sobre o Atlântico. Os nossos 15 países compõem um mosaico bastante diverso em termos de população, com cerca de 400 milhões de habitantes, dimensão territorial, percurso histórico, recursos naturais, desenvolvimento socioeconômico e maturidade das instituições democráticas. E a verdade é que, nestes 47 anos de existência, a CDAO tem procurado realizar um trabalho de harmonização, tendo em conta essas especificidades, para além da concretização do seu quadro institucional, que inclui os diferentes órgãos, como é o caso do Tribunal de Justiça, sempre com vista à promoção do desenvolvimento dos países membros. Infelizmente, estes últimos anos têm sido de enormes desafios para a nossa comunidade e para a humanidade em geral, mas fustigando com maior intensidade as economias menos vigorosas, como é o caso dos nossos países. Aos efeitos devastadores da pandemia da Covid-19, que ainda não terminou, juntam-se agora as terríveis consequências da guerra na Ucrânia, ainda sem fim à vista. Por outro lado, neste momento, alguns dos nossos países enfrentam focos de terrorismo, alteração da ordem constitucional, diferentes tipos de tráficos e outros problemas, cuja conexão à criminalidade transnacional organizada, repito, não pode e nem deve ser negligenciada. São demasiadas ocorrências que, de certo, perturbam a normalidade da produção e das transações comerciais, já com registro de escassez de produtos e preços inflacionados, agravando a pobreza e postergando a retoma econômica. De referir que, precisamente, a vertente econômica é aquela que na nossa sub-região ainda vinha a batalhar para atingir o dinamismo que seria desejável. Somos chamados a ser mais fortes e eficazes na gestão da pós-pandemia, a ser mais ousados também, designadamente no aproveitamento de oportunidades e na valorização de recursos endógenos, a começar pelos recursos humanos. Por exemplo, temos de estar preparados para outras pandemias e para as endemias. Temos de estar em sintonia quanto à centralidade política e estratégica das questões da saúde e da segurança sanitária, incluindo a capacidade de produção de vacinas e medicamentos em geral. Ou seja, não podemos ficar à mercê de um sistema cujas iniquidades a pandemia colocou inteiramente a descoberto. Porventura, teremos de ter coragem para reequacionar prioridades e questionar formas instaladas de gestão de interesse público. Cabo Verde é um dos países com mais impacto da Covid-19, o que se traduz na redução do seu PIB em cerca de 15%. Setores vitais da nossa vida económica e social foram fortemente atingidos, com algumas regiões do país a necessitar de urgentes medidas de discriminação positiva para que possam rapidamente reerguer-se e assim voltar a contribuir para o ritmo do crescimento nacional. Apesar deste contexto de intensa crise econômica e num gesto demonstrativo da importância estratégica que atribuímos à integração na região, foi aberta a nossa embaixada em Abuja, na Nigéria, no ano passado, com poderes de representação junto da CEDEAO, visando o incremento da presença e participação na organização subregional. Naturalmente que, como bem disse aqui o professor Salomão, que a integração regional é sempre um processo que vai evoluindo com custos e benefícios. Temos de ser perseverantes. Podemos aprender com o que existe de positivo em experiências anteriores, como é o caso da integração europeia. Por outro lado, os exemplos menos bem conseguidos servirão igualmente de ensinamento para evitarmos as mesmas falhas. Os acontecimentos mais recentes a nível mundial e ainda em curso evidenciam uma permanente mutação com as relações entre os Estados a complexificarem-se progressivamente, pelo que a CEDEAO deverá estar ela também atenta a estes desafios e pugnar sempre pela via do diálogo e da negociação para a resolução dos desentendimentos, divergências e disputas. Estamos já num período disruptivo no plano internacional. A economia em crise, mas também vários princípios e valores que já tínhamos por consolidados foram postos em causa. É preciso que nos reencontremos no que nos é comum e essencial, pois que desse património comum dependem a sanidade, a estabilidade, o futuro, afinal, da comunidade internacional. A nova ordem mundial em gestação irá, com certeza, exigir de nós mais integração regional e continental e obrigar-nos a profundas e radicais reformas nos planos nacional, da região e da África, com impactos na divisão de trabalho entre esses diferentes níveis de governança. Estou seguro que nesta conferência internacional serão abordados assuntos relevantes no processo de integração da CEDEAO e para o avanço do direito comunitário. Será uma oportunidade para se aprofundar o debate e se aproximar das soluções e modelos que melhor traduzam as aspirações dos povos da sub-região e que a CEDEAO possa dispor de instituições democráticas, transparentes e eficazes e que sejam verdadeiros instrumentos da promoção do desenvolvimento. Com efeito, os principais propósitos, de acordo com o disposto no artigo 3º do Tratado Revisto, são, abro aspas, promover a cooperação e a integração, tendo em vista uma união econômica na África Ocidental, para elevar o nível de vida das populações, manter e aumentar a estabilidade econômica, fortalecer as relações entre os Estados-membros e contribuir para o progresso e desenvolvimento do continente africano. Fecho aspas. Nessa senda enquadram-se os desígnios da conferência que ora se inicia. E abro aspas, avaliar criticamente o ambiente jurídico para a implementação do Programa de Integração Regional da CEDEAO e o impacto do regionalismo, do supranacionalismo e das soberanias nacionais dos Estados-membros no processo de integração, e fecho aspas. Quanto ao alcance e à velocidade da integração, entendo que há que estar sintonizado com as práticas e normas de outras instituições similares que souberam inovar face a situações complexas e que podem assemelhar-se às por que passamos atualmente. Esse nível de integração regional deve pressupor, igualmente, que os diversos Estados-membros disponham de estruturas institucionais robustas, o que passa pela reforma e modernização do Estado e a criação de instituições políticas e económicas inclusivas. Tal desejo também é extensivo às instituições de administração da justiça, que, como pilares essenciais do Estado de Direito, têm de ser sólidas e inspirar confiança aos cidadãos como garantes dos seus direitos fundamentais. Os efeitos de uma integração regional bem-sucedida são mais do que evidentes. Destaco a possibilidade de fortalecer o desenvolvimento econômico, melhorando o nível de vida das populações, contribuindo que uma parte muito significativa possa sair da pobreza, o que terá um enorme impacto numa ansiada retoma económica, tendo em conta as consequências ainda prevalecentes tanto da pandemia da Covid-19 como da guerra na Ucrânia. A promoção e consolidação de sistemas democráticos de governo, a tolerância e o respeito pelos direitos humanos, a eliminação de todos os tipos de discriminação devem fazer parte de forma permanente do catálogo de preocupações da CEDEAO e do seu tribunal, em particular, de assinalar que, no capítulo dos direitos humanos, os progressos são significativos, registando-se o facto de, na sequência de alterações ao seu protocolo original, através do protocolo adicional de 2005, a jurisdição do tribunal ter sido alargada para abranger casos de violação dos direitos humanos nos Estados-membros. Em relação a essa proteção dos direitos do homem, que vem sendo exercida pelo Tribunal de Justiça da CEDEAO, a qual continuamos a reconhecer uma enorme importância, o principal desafio que se coloca à nossa comunidade é a criação de um quadro jurídico institucional que assegure o princípio da complementaridade entre as jurisdições nacionais e o Tribunal de Justiça da comunidade. De realçar que o desempenho deste tribunal é bem referenciado no continente africano e não só. Neste sentido, defendo o seu papel na interpretação dos textos comunitários, na solução dos conflitos que possam surgir no âmbito da integração regional e o reforço da sua função consultiva em relação aos demais órgãos da comunidade. Os juristas, advogados, académicos e outros especialistas com ciência na matéria e que participarão nas discussões, certamente que nos irão elucidar quanto à relação entre a integração regional e a proteção regional dos direitos humanos, bem como quanto a outras incidências. A livre circulação de pessoas, de bens e serviços ocupará um lugar de destaque e merecerá a atenção desta conferência, tendo em conta a sua importância para a integração regional. Infelizmente, em alguns dos nossos países prevalecem certas situações de instabilidade política ou de disfunção no funcionamento normal das instituições. Este descompasso constitui um óbice para o desenvolvimento da nossa sub-região e um obstáculo ao processo de integração regional, que se quer inclusivo e abrangente, numa altura em que alguns dos países irmãos se encontram suspensos por razões que são conhecidas. Quanto à forma de aceder ao poder, não é pela via de eleições, de acordo com a Constituição. E quando se verificam atividades de grupos terroristas, estamos sempre perante situações de ameaça à paz e à segurança na nossa sub-região. E insisto no seguinte: a instabilidade inerente a este tipo de ocorrência torna-se um entrave ao processo de desenvolvimento econômico. Temos, pois, de redobrar esforços na busca de soluções sustentáveis e duradouras para as cíclicas crises que teimam em afetar a CEDEAO. Sobretudo, temos de ser intransigentes perante toda e qualquer forma de subversão da normalidade político-institucional. Não temos o direito a ser nem dúplices, nem condescendentes. Isto aplica-se a todos, em todas as instituições e instâncias. No fundo, trata-se da generalizada assunção da constitucionalidade e dos cânones do Estado de Direito Democrático. Cabo Verde congratula-se com todas as iniciativas tendentes ao reforço dos processos democráticos e da boa governação. É, na verdade, inabalável o nosso compromisso com os valores, princípios e regras do Estado de Direito Democrático e a aposta que é da CEDEAO, mas é também da União Africana, com vista à sua consolidação e defesa nos planos continental e regional. A nossa integração regional, apesar das normais dificuldades de percurso, tem um registro de progresso já conseguidos, que devem ser consolidados e ampliados, sempre tendo em vista o objetivo maior, que é o desenvolvimento e o bem-estar para todos os povos da nossa sub-região. E é com esta nota positiva que concluo a minha intervenção. Reitero as felicitações ao Tribunal de Justiça da CEDEAO e a nossa conterrânea, que é juíza deste tribunal, a doutora Januária Nascimento, Januária Costa, por esta louvável iniciativa e pelo facto de terem escolhido a cidade da Praia para a realização deste tão importante evento. Declaro assim aberta a Conferência Internacional modelo de integração da CEDEAO, as implicações jurídicas do regionalismo, da soberania e do supranacionalismo. Thank you very much. Merci beaucoup. Muito obrigado.
Merci, Excellence, Monsieur le Président. Few informations before we close. After the ECOWAS anthem, we will have a group picture. The high table, judges of ECOWAS, and Chief Justices of the representative present. I'm calling on hostesses and the two protocol assistants from Court of Justice to lead these high personalities to the entrance. Information division, please help. There will be a coffee break of 15 minutes. 15 minutes to allow us redesign the podium for our discussions. And the last one, kindly don't go out the hall with your earpiece, please. If you are moving out of the hall, please keep your earpiece on your chair. Thank you very much. With your permission, Mr. President, we'll kindly call the techniques to give us ECOWAS anthem and Cabo Verde anthem, please. Thank you. Please remain on your seats while we allow His Excellency and the High Judges for the group picture. Hostesses, please, can you lead our respectable dignitaries to the group picture? Ezekiel, come over. Come and lead them. Chief Justices, ECOWAS Rep, Honorable Yoni, Honorable Bafubuni, please join the train of the group picture, please. Techniques, please come and reset the podium. Come and reset the podium, please. We have 15 minutes.
CETEPAN.
Hello. Hello. Please kindly resume your seats. Hostesses, please help me call all participants. All participants, kindly resume your seat, please. Huh? No. Hello, Mr. Lassisi, Mr. Ezekiel, please help me call on participants. Please, hostesses, call on participants. yo et non là, au test son âme là. Alors là, si, quoi Ézéchiel là. Please kindly resume your seat, please. Ezekiel, please bring participants in the hall, please. Call on participants to resume, please. Well. Please, resume your seat, please. Kindly take your seats. Thank you very much. Dunya, bring participant in. This is empty. Full as a play. Ezekiel, where are the participants? Bring them in, please. So let us have a house together, please. Take your seat, please. Thank you. Kindly take your seat, please. Well, techniques, internet is not working. Please try your best. We are about to start our main deliberations. One house, please. We are going to start with sub-team 1. Sub-team 1, which is ECOWAS integration model. This session is to be moderated by Honorable Justice Emmanuel Yoni Kulendi, Justice of the Supreme Court, Ghana. I'm calling on Justice Yoni on the podium. Justice Yoni, please. For the presentations on sub-team 1, I'm calling on Professor Mohamed Taufik Ladan, Director General, Nigerian Institute for Advanced Legal Studies. Calling on Professor Amos Enabulele, Professor of International Law, University of Benin, Edo State, Nigeria. We were to have two other presenters, Mr. John Azuma and Daniel Lago. We are still working on trying to reach them by internet. If techniques allow it to come up. These presentation and discussions will hold until lunch break time, so that once we close from here, we go for lunch, we come no more until tomorrow. Justice Kulendi, the Chief Registrar has requested me to inform you that and other moderators that at the end of your session, you come up with a conclusion on your on the group you have moderated. Thank you very much. You have the floor, my lord.
Thank you, Mr. Moderator. I would like to express my profound gratitude to the President and management staff of the ECOWAS Court of Justice for taking another actually very bold step in bringing us to prayer. As far as I'm concerned, the topic assigned to me is on ECOWAS integration model, and then I adjusted the topic to read ECOWAS integration model from intergovernmentalism to supranationalism, because I believe strongly, unlike the keynote speaker that actually made the point, with all due respect, that ECOWAS does not have an integration model, or that if it has, it is running an intergovernmental model. I disagree completely, because there is evidence to that effect that ECOWAS did practice for about 30 years intergovernmentalism, but it was actually fraught with many difficulties and challenges in practical reality for 30 years. So ECOWAS embarked upon a reform agenda. And that reform agenda, started from 1993. A departure, may not be a radical departure, but it was a shift from intergovernmentalism with all its problems, and the difficulties that member states, the institutions of ECOWAS, as well as citizens of ECOWAS, really encountered for those 30 years. And that shift from 1993 to date is essentially a shift from the negative practice of intergovernmentalism to supranationalism. And supranationalism may not necessarily have provided a perfect result, but it is yielding result nevertheless in a very slow but surely. And I've provided for you in my paper 3 tables, tables 1, 2, and 3, to show you evidence of the shift from intergovernmentalism to supranationalism, and to also show the steps that ECOWAS took, and to also show that, first and foremost, the shift essentially has now given us, one, an expanded decision-making processes that we never had before 1993. That is one evidence. Second evidence, there was also an expanded decision-making bodies beyond the authorities of heads of state and beyond the ECOWAS Council of Ministers, to now include ECOWAS Commission that was transformed from the Secretariat to the Commission, and to also include ECOWAS Parliament as another core decision-making body in an enhanced manner. So you have enhanced decision-making processes, enhanced institutional making bodies in ECOWAS, a shift completely away from intergovernmentalism. So anyone that says that there is no model for ECOWAS, or that ECOWAS is running intergovernmentalism, even as of today, honestly speaking, with all due respect, is a misplaced statement, and I disagree completely, because that evidence is very clear. You can read my paper, tables 1, 2, and 3, and then figures 1 and 2, you will see clearly that evidence of the shift. Another evidence that I would like to put forward is that there is also an enhanced mandate, enhanced powers, and enhanced status of both the ECOWAS Commission and the ECOWAS Parliament. This never existed before 1993 under the intergovernmentalism. It never existed. Check the record. Check the instruments. It never existed. It only existed post-1993 when we transformed from intergovernmentalism to supranationalism. It doesn't have to be a perfect move, but it was a slow but a sure process. And that is the second evidence in an expanded way that I'm talking about. Another evidence to show that there was a shift from intergovernmentalism, which we practiced for 30 years with very negative record and poor performance, to supranationalism from 1993 to date, is the enhanced roles of the Commission to use rules. Sometimes we expect a lawmaking to be transferred by the authority of heads of state or council of ministers to the Commission. No, it doesn't have to be the lawmaking, core lawmaking authority. That is not the essence of supranationalism. The essence is that is a key decision-making process. A key decision-making process, has it been transferred to the ECOWAS Commission to be able to take a decision for and on behalf of member states and on behalf of the organs of the community? If the answer is yes, then that is an evidence of a semblance of a step. It might be a negligible one, but it is a very important step to show the departure from the intergovernmentalism that we practiced for 30 years, from 75 to 1993. And that actually, is evident, from the role of the ECOWAS Commission today. To use rules. Rules may be a subsidiary instrument. It is nevertheless a component of an authority given for the Commission, unlike under the ECOWAS Secretariat, to take a decision that is binding. The Supplementary Act makes it very clear, 2010, that the rules of ECOWAS Commission to be able to translate the decision of the ECOWAS Authority Officer and that of the Council into effect for and on behalf of the member state and for and behalf of all the organs of the ECOWAS as an institution is on the same equal footing, with that actually of the Council of Ministers. Check the law. Let me give you a particular reference. And so it is actually not actually correct to say that ECOWAS did not move from intergovernmentalism to supranationalism. It is completely not true. And I think we also need to, appreciate one fact, and that is that the revised treaty of 1993 essentially reaffirmed the establishment of ECOWAS, and decided under Article 2 that it shall ultimately build the sole economic community in the region and for the purpose of economic integration. That is actually true. It is also true that it ensured that the member states feel, and they must continue to feel, that sovereignty is not necessarily actually threatened just because you've empowered some organs of the community. Because you cannot have any meaningful economic integration anywhere in the world without ceding part of your legal sovereignty. And that does not really take away, the other component of sovereignty of the member states. And I think this is where the fears actually lies. So sometimes, is the lack of understanding or clarification of what does ceding part of the sovereignty of the member state means. It's simply about ceding a component of your legal sovereignty where an institution that you created on your own voluntarily, that you empowered voluntarily, and that you also enhance its powers voluntarily, and you also fund voluntarily, should be able to take a decision for the collective interest of all. I think that's where the key point lies. And so member states need not actually entertain fears that ceding part of their sovereignty to ECOWAS or any ECOWAS organ will completely reduce them to nothing. That is not the essence of regional economic integration. Because if member states are truly independent, why do they have to voluntarily belong to regional economic integration bodies all over the world? In ECOWAS, in SADC, in EAC, in the Maghreb Union, in the EU, in the OAS, in the American Union. It is because there are benefits derivable from regional economic integration bodies. That is why sovereign entities voluntarily join economic integration bodies like ECOWAS. That's the reason. So when they voluntarily join, all they need to be made to understand and for them to feel more secured is that parting with part of their sovereignty to such regular economic integration bodies does not necessarily reduce them to ground zero. It does not. It only enables them to benefit more because they cannot continue to remain sovereign entities like islands on their own. They cannot. Not in today's regional economic integration arrangement. They can never. In trade and investment, they can never win. So they have to belong to a bigger market in size, in population, and also in funding actually strategy, and at the same time, in an effort to improve on our infrastructure deficits, which will really actually propel greater prosperity for all in the sub-region. So this is the essence of ceding part of legal sovereignty. And it does not necessarily reduce the sovereign entities to nothing, because they gain more in regional economic integration bodies when they cede part of the legal sovereignty to the body and the organs of the body to take decisions on their behalf, on behalf of the citizens, and on behalf of the organs created by actually the member state. That is the essence of supranationalism. And it also benefits member states and the citizens that, look, our actually, independent sovereign state believe in the collective survival of our sub-region. They believe in collective prosperity of our sub-region, and they also believe in the collective progress and development of the sub-region. Because the African Economic Community, otherwise known as the ECOWAS, actually, Abuja Treaty, AEC, with the vision that the regional economic integration blocks of ECOWAS, SADC, EAC, Maghreb Union, EACS, all these actually 8 recognized regional economic bodies are meant to be or serve as the building blocks for the ultimate goal in Africa, and that is African Economic Community. They are moving actually slowly but surely, and the RECs, like ECOWAS, are going to remain the most viable, building blocks for us to achieve the ultimate goal of African Economic Community. Somebody once asked, who is implementing the Abuja Treaty on African Economic Community? I said, of course it's been implemented, because it is the same treaty that created the pathway for African Continental Free Trade Area. One problem that I agree with the keynote speaker on, is that in the effort by ECOWAS to move towards supranationalism, the question that you ask critically is, how far have we made progress in terms of economic integration? And our intention actually and effort to really actually integrate the sub-region, has really actually provided us with many answers, many questions and answers, because we've not made significant progress with regards to customs union. We are still struggling with free trade area, and we are still struggling with the money integration. And this is not peculiar to ECOWAS. In fact, we've made significant progress, more than actually other RECs, in Africa. So the fact that we are having problems in making headways in 30 years to complete the free trade, area actually, component, or the market integration component, or the custom union component, or even the monetary integration component, does not mean that we're not making progress. And I agree with the keynote speaker on this point, that if you are judging or you are assessing the progress made, then you can score not more than 50-55% actually of ECOWAS on this on this component. But it doesn't really take away our commitment to move slowly but surely. And in conclusion, I would like to actually draw attention to the fact that, one, it is actually true that we did actually have difficulties in the practice of intergovernmentalism, and lessons were learned. Lessons were learned. For instance, let me give one example. When we were practicing actually intergovernmentalism, member states actually, are used to, promulgating, protocols, and conventions, but then without necessarily showing the next degree of commitment, in their ratification, or in ensuring that those member states in the common law jurisdiction within ECOWAS, who after ratification, they need to domesticate them before they become effective or implementable actually something, could not do so. So we ended up having 65% of all the ECOWAS protocols and conventions under the intergovernmentalism actually arrangement in 30 years, never ratified, talk less of being actually, domesticated by member state. So what is the use? What is the use? This is one clear example as to why we have to move away from intergovernmentalism to supranationalism. So what happened in supranationalism? The legal regime actually changed. That look, you don't need to waste the time of member states, irrespective of the jurisdiction, whether Lusophone, Francophone, or Anglophone, or common law, civil law actually jurisdiction. Once actually member states actually agree at the level where a supplementary act becomes actually an adopted instrument, then it becomes legally binding actually and operational in member state. And that is a monism approach, But surprisingly, all the common law jurisdiction members of the experts were able to be boxed into this monism, and it has come to stay. So we don't need protocols, we don't need conventions to be ratified, signed, ratified, and domesticated. Under the new arrangement, once the Supplementary Act is adopted, it becomes actually legally binding operational act of member state. So I was surprised myself how common law jurisdictions like Ghana, Nigeria, Sierra Leone, Gambia were boxed into this monism, and it works, and there was no complaint, and there is no retraction. This is the current regime today. And as far as I'm concerned, you can see the evidence, of that monism, which we actually have to kick against, but then it's been adopted. And the Supplementary Act regime today is once it is adopted, it becomes and there is no story, unlike under intergovernmentalism, where, Ghana, Nigeria will say, I need to go back, ratify it, then go back again, and then domesticate it before it becomes having the challenges of member states trying the judgments of the ECOWAS court, treating the judgment as to whether it's or not. And I think this is where ECOWAS Court of Justice has done a lot of advocacy. And I've always made this point, that the international conferences that ECOWAS Court of Justice has been actually organizing every year, in the last 10, 15 years, was not even, and is still not the job of ECOWAS Court of Justice. Is the job of the ECOWAS Commission. And it has not actually been doing its job. And I've said it actually several times, and I'll repeat it anywhere, anytime. But the court is doing so annually in order to register the court in member state in terms of visibility. And in terms of also taking the court or registering the court's presence in member state by going around. That is a very good strategy on the part of the court. But as far as I'm concerned, the rediscussions on each and every instrument and every decision-making process still has to be done by the ECOWAS Commission in going around member state in holding this kind of strategic engagement. What the court is doing is on the part of the court, and it's enough that it is actually registering its presence and engaging stakeholders. Thank you very much.
Well, thank you, Prof. I mean, this is the first professor who has not used all the time that we gave him to speak. And I think it's commendable having regard to the fact that we're pressed for time. So Prof has, by my computation, he has 8 minutes he didn't utilize. So I'm generous to add it to you if you are a different kind of professor. And so, ladies and gentlemen, this time, the floor is turned over to Professor Enambulele. Okay.
Good afternoon. I would like to start by thanking the courts for inviting me once again. Thank you for organizing this event every year. I always look forward to coming here because whenever I come, there's always something to go back home with. We learn from ourselves, from each other. We talk to each other, which is something you don't find if I'm back home just at my university teaching my students. I also want to thank the chairman for the generous offer to add 8 minutes to mine. I think that's good. Okay. There are certain words that we just say and we throw around, but when you interrogate them within the context of ECOWAS, you find them to be largely, to a large degree, empty and non-existent. I'm choosing my word very carefully. I'm saying to a large degree. The keynote speaker has set the pace this morning, and he has given me the impetus to say what I'm going to say. We talk about community, ECOWAS community. We talk about integration. We talk about supranationality. If I ask, do we have an ECOWAS community? What do we mean when we say a community? To my understanding, if you are talking about a community, you are talking about a community of 15 states of ECOWAS where the borders have been broken down. Not a community that you have different borders. So you talk about community law. You are talking about a law that is applicable, a unitary law within the community. In Togo, out of frustration perhaps, I postulated Jurisprudence Union. I was talking about Jurisprudence Union. So I said, look, There's no jurisprudence in the in the ECOWAS. So if you are talking about community citizen, you are saying, okay, a citizen, I'm a Nigerian, by virtue of being a Nigerian, I'm an ECOWAS citizen, a Ghanaian. If we move and decide to say, okay, we are in Cape Verde, we are protected by ECOWAS. We are ECOWAS, we are coming here by virtue of being ECOWAS citizens. We are not coming here to begin to deal with ourselves as Nigerian citizens or Ghanaian citizens. Where is the community in ECOWAS? Now, if we have a problem with the issue of community, look, I'm not saying that ECOWAS has not tried, but ECOWAS has made attempts at building a community, at integrating, at creating supranationality, but that attempt doesn't seem to have been good enough. If there's no community that you can say, well, I'm a member of ECOWAS community, I can move from one point of ECOWAS to another, and I'm recognized, and I'm given that recognition as ECOWAS citizen. If I cannot say this ECOWAS law, for instance, let me ask you, we all came from different countries. In Nigeria, for instance, when I teach my students or I'm advising a client, the expectations of that advice is geared towards Nigerian law. You hardly advise a client and you say, okay, this is ECOWAS law, this site applies to you. We can make all the laws at the ECOWAS level, that's fine. This site applies to you. And when I'm ordering my own affairs, I hardly think of how ECOWAS law affects me. I'm looking at Nigerian law, and I'm sure it's the same with many of us. I lived in the EU for a long time. And in the EU, in Britain, one of the most popular, most powerful piece of legislation is the Equality Act. The Equality Act a major part of the Equality Act was an EU directive, which has exited the EU now. EU directive. So you're advising a client, or you have been dealt with discrimination and all of those. You have been treated badly in your place of work. You come back to the Equality Act and say it affects you. You know, and when you are doing that, you are thinking, oh, this is an EU legislation. It applies EU-wide, which was why one of the reasons why Britain decided to exit the EU. But in ECOWAS, do we have any such? So let's be honest with ourselves and interrogate this. Now, you come to integration. You know, I took an expansive view of integration in my paper. The reason I did this is to make us understand or to make us see that it is not enough to just say, okay, ECOWAS has said it's a regional organization, countries have come together, then we have integrated, and that integration answers everything. No. And I said in my paper that, look, countries could integrate for different reasons. And I dare to use the UN. I know some people may want to disagree. I dare to use the UN to say, UN is an amalgam of states. It's a collection of states. You know, these states, UN is based on intergovernmentalism. It has no business with supranationality or whatever. But UN is integrated in one respect, one major respect that you may agree, you may disagree, in the use of force. If you look at Article 2.4, you look at Article 51, you look at Chapter 7 that deals with the power of the Security Council. Now, the powers of states to use force was moved over to the Security Council. Security Council takes decision on enforcement measures. Forget about the veto of the Big Five. I'm not talking about that. But when U.S. Security Council was going to intervene in Iraq, Saddam Hussein didn't have to come and sit down and say, yes, I'm consenting for you to come and intervene. When we were going to intervene in Libya, Gaddafi didn't come and sit down to say, I'm consenting that you intervene. So to that extent, there's a level of integration. Integration is something that happens mainly at intergovernmental levels, where you have treaties that you have entered into to say, okay, because of this agreement that I've entered into, I'm ceding part of my sovereign power, because states are very powerful entities. They are so powerful. And when you talk about sovereignty, the sovereignty of a state allows the state to take actions that it wants to take, to do whatever it wants to do, subject to that state ceding part of that sovereignty by treaty. So if a state decides to say, okay, this is my reserve domain, there's something probably in international law, we call the reserve domain of state activities, of state powers. The reserve domains, those domains that the state has reserved to itself. State says, okay, usually talk about nationality, territoriality. I'm going to talk about them within the context of my paper. Over time, from the time of the Permanent Court of International Justice, which is the League of Nations, up to the ICJ, up to the UN, it has always been that states, when it comes to nationality, that it remains within the reserved domain of states. Only states determine the criteria for conferring nationality and all of that. When they've done that, it may have international application. That's another question altogether. Then territoriality. You want to come into the territory of a state, the state has to consent. Immigration is a part of territoriality. All those two attributes of a state, they cut in when you begin to talk about integration and begin to talk about territorial supranationality. Now, a state has reserved domain, and the state says, okay, this is ECOWAS. We are coming together as ECOWAS, as 15 states of West Africa. And Nigeria says, okay, well, or Cape Verde says, well, I want to be part of this. And I say, okay, well, this is what we're going to do. We want to open up our economies. We want to create a free trade area. We want to create a custom union. We want to create an economic union. And the state says, yes, I'm on to that. There's a 1975 treaty. I'm signing up to that. The moment the state signs up to that, it sees part of its sovereignty. Because there are already now things that are involved in that treaty that takes away the power of the state to take unilateral actions. And the state does that. When that is done, there's the level of, at that point, if that creates some integration, there's a level of integration that has been created. In the ECOWAS, we've had 1975 treaty. And part of the main purpose of that treaty was to integrate us economically. There's an economic aspect of it to integrate the states economically. And that treaty set standards to say, okay, these are the things I want to achieve. Within this time, we'll achieve this. Within this time, we'll achieve this. And within the framework of that treaty, the Free Movement Protocol was made. Citizenship, definition of citizenship protocol was made in 1980, which means that even the states as at that point agreed that we're going to create free movement. We're also going to have citizens, because you cannot be talking about free movement without citizens that will benefit from it. And which, again, makes a difference between the UN system that I mentioned and the regional system that we're talking about. The UN system is intergovernmental. It doesn't deal with you and I. The aim of the UN can be dealt with without you playing any part. But in ECOWAS, it's not going to be the same. ECOWAS cannot achieve its purpose without you and I getting involved. Okay? Now, you come to supranationality. You can have integration. You can have integration without supranationality. Supranationality is an addition upon integration. And at that point that you say, okay, we are going supranational. We want the municipal system and the international system, the integrated system internationally, if there is, to act in the same manner. And that is done by law. That's the point I want to quickly disagree with my co-panelists this afternoon. He has mentioned something very vital. When you're looking at supranationality, we have made a habit of interrogating ECOWAS from the top, not from the bottom. We need to go back to the states. You can't build something on nothing. There has to be a foundation. As they will say, if the foundation is destroyed, what shall the righteous do? Because when the foundation is not there, no matter how good your intentions are, it's not going to work. Now, under the 1975 arrangement, we entered into these treaties. How many of those states domesticated those treaties? It's a principle of international law that if you enter into an agreement, it is incumbent on you to take steps municipally to make sure that that agreement takes effect if it's an agreement that's intended to have a municipal effect. Not many of them did that. Now we have constitutional provisions. Sorry if I may just grab a cup of water. Now, we have constitutional provisions in our municipal law. I'm going to cover some Nigerian law. Section 12(1) of the Constitution says that no agreement, no agreement can have municipal effect in Nigeria until that agreement is domesticated. If Nigeria likes, if the president likes, or whoever is making the treaty, let him go and make any treaty to say this treaty will be applicable in Nigeria tomorrow, it is not going to work. It is not going to work. So the idea of there being monism in Nigeria today is something that needs to be interrogated further. So it's not going to work. So the first point is we need to work towards building a community, that we really have a community, because if there's no community and you are talking about integration, why are you going to integrate? How are you going to want to integrate economically? Sorry. You want to integrate economically. To say, okay, there's going to be free movement of goods, there's going to be free movement of persons, there's going to be right to of residence and all that. There are borders here and there. There are artificial borders or even legal borders here and there. Those borders need to be dismantled. If you don't dismantle them, give rights to anybody, the person is not going to enjoy that right. It's not possible. Then when you have not achieved integration, you say, okay, now it's supranationality. What are you building it on? They have to be built, there are layers that need to be built one after the other. And so there's a need for us to begin to look at, okay, have we actually succeeded in building a community? Can we actually say that we have a community? If we have a community, have we integrated? Have we removed all the barriers that need to be removed for this integration to happen? If it has happened, as at the time the 1975 treaty was made, even 1993 treaty, states took steps to domesticate those that needed to domesticate. They did 2 steps to do what they needed to do. And now you are saying, okay, decisions of organs or institutions of ECOWAS will be applicable. It will be so easy. But now you are building decisions of ECOWAS and say, the Council of Ministers can make sure it will be directly applicable to. It is not going to work because the framework is just not there. So having said that, let me just quickly return so that I don't spend all the time talking about this. So I've mentioned, just go to my power one after the other now. Sovereignty, I've spoken about sovereignty already. I'll just jump and move away from there. Now, types of integration. We're asked to speak on types of integration. In my own view, I decided to see them as stages of integration instead of types of integration. Because what you see listed as types of integration, most times they are stages of integration. If you look at Article 3D of the reverse treaty, you see an intention of a free trade area, then you have a customs union, and all of that progresses. Even the EU, the EAC, also like that. So they are really, to me, they are not types. To me, I would rather call them as stages. So you achieve one stage. If you have not achieved a free trade area, you are talking about a customs union. You have not achieved a customs union, you are talking about, you're not going to make any headway. So those stages, we need to begin to ask ourselves, have we actually achieved this? So that we can move on to the other. If you have not achieved one, you are building another one on top, there's going to be the problem, which is part of what we are facing today. In my paper, I'm just going to skip that. Maybe I'll speak to it later so I don't waste too much time. I drew a distinction between integration and supranationality. Try to make us see that there are 2 different concepts. I'm sure we all know that. There are 2 different concepts. There can be integration, as I mentioned, without supranationality. So that's, I think that's taken. I talked about specific approaches, the EU approach. I think an aspect where I slightly disagree with the keynote speaker, he said there's no model, couldn't identify any integration model in the ECOWAS. I think ECOWAS seeks to copy the EU with market and rights approach. I think that's the approach that ECOWAS seeks to pursue, to use for its integration, create a market environment, then protect the rights of individuals to enjoy that environment. But whether ECOWAS has actually succeeded in doing that is another question altogether. I was also asked to speak on the Committee of Eminent Persons. We all know how that committee came into being and what is suggested. That committee was actually very interested in moving ECOWAS away from this intergovernmental approach that ECOWAS operated all the while and advocated a situation where institutions and organs of ECOWAS will be able to make binding decisions, which, of course, is the environment that we seem to be, but in practice, it hasn't gone as it should go. In conclusion, I'll just conclude. In concluding, today, I would like to mention that in every integration scheme, where you have countries coming together to integrate, you have the rich, the not so rich, you have the poor country. You have the stable, the not so stable, you have the unstable country. All of them have something to bring on board. Cape Verde is a beautiful small island. It has something to bring on board. Niger is a large expanse with a large population, a landlocked state. It has something to bring on board. And all the states have something to bring on board. So nations or heads of states seem to always think that the other state is a problem. And so if I open up my borders, if I allow these other nations, the people to benefit from this integration, it's going to hurt my economy. Usually it's not necessarily true. When Britain thought of exiting the EU, of course, because of the Eastern Europeans that were admitted into the EU, they thought, well, they had nothing to lose. But after they exited, they discovered that they had a lot to lose. There were no drivers to drive their trucks. Goods were drying up in the shops. There were no seasonal workers to pick their strawberries and their fruits. That was how bad it went. So for every country, there's always something to benefit. And I also want to reiterate the point that Mr. Farano made in Togo. You know, the people who run our countries, for the time being, whether you are dead today, you may not be dead tomorrow. Countries exist in perpetuity. Like somebody will say, they have no souls to be damned or body to be kicked around. So you will go, but the country will remain. But we see a situation where many leaders who, when they head sway, refuse to allow to do the proper thing, refuse to enforce the judgments of the court. They come back when they are not there anymore to say, oh, the court wants you to help me and all of that. So it's in the interest of all of us, the interest of our countries, the interest of us as citizens of our countries to ensure that ECOWAS actually works. And that will not happen until we begin to interrogate it from the basis. We need to go back to our countries and look at the things that are wrong. We cannot get it right from ECOWAS level. It's never going to happen. No matter what we do, no matter how many supplementary acts, no matter how many treaties the nation sign, when the foundation within the municipal law is not right, it is not going to work. We are in Mali, and a very senior official of Mali was saying that year, he said, I don't want to mention his destination, but it was a judge of the Supreme Court. He said, we gave a decision in Mali. One rascally lawyer took it to ECOWAS Community Court of Justice during my presidency. I said, sir, he was not rascally. He was just only acting in accordance with the law. That is the highest court. Somebody's making such a statement. As far as earlier as late as 2018, it means that we have a long way to go. It means that we need to work from the municipal law upward and achieve whatever we seek to achieve. Thank you.
Well, thanks, Prof. I think Prof followed the example of his brother. He did not also use all his 25 minutes. But that leaves us a lot more time for deliberation, for comments, for contributions, and for questions. And, Prof. Laden says you will have time to do that. He says he will find use for his 8 minutes. So can we have, we have a microphone on the floor. The deliberation is open. Yes, my Lord Chief Justice has his hand up on the first row. And then after my Lord Chief Justice, I recognize my brother in the middle and then my brother to my right.
Yes.
Madam.
Let me start by first person, Chairman, first of all.
Madam, my Lord, please.
Let me start.
Bring the microphone to my brother in the middle so that when my Lord Chief Justice finishes, he can kick in and then we...
Let me start by commending all of you, starting with the keynote speaker who opened up the subject. And that has been followed up by learned panelists that we have with us. I don't quite agree with Professor Laban, is that the name? Ladan. Yes. That Professor Solomon Ebobra did say that there was no supranationalism. He said, he actually started by saying you have the 1975 economic integration, then you moved to 1993, that the structure began to change, and in 2006 where you had entry protocols, and that was a move towards supranationalism. It has its problems. You, the other speakers, has highlighted some of the problems, and I do agree with these things. For instance, now we are talking. Professor Ladan actually mentioned the issue about ECOWAS Commission coming up with a decision, and that decision should be applicable to all the states. In Africa, West Africa, as we know, we have mono-states, we have dualist states. The dualist states will say, like Sierra Leone, Ghana, and other countries, it's in their constitution. It has to be domesticated before it is applied. With such things, it becomes extremely difficult to come up with a decision. Perhaps in these national constitutions, there should be changes there, wherein, for instance, they would say whatever ECOWAS comes up with, there is no need, even if you're a dualist state, so far as ECOWAS laws are concerned, it should be applicable without domestication. Perhaps that's the way to go forward. Again, you spoke about the issue about the resources, about the community members. As a Sierra Leonean, it does not matter, I'm not a Nigerian. But then, what Nigeria is getting, I should be able to benefit from it. The laws are not there to allow that to happen. And insofar as that is not the case, there cannot be anything like supranationalism. So these are concerns which we have to address. Unless we are able to address them, we are just struggling. We are moving towards it. In order to actually hit the point, there is much more practical things that need to be done. Thank you.
So, my brother in the middle, you already have the microphone, don't you? Please.
Mr. Chairman, my name is Professor F.C. Nwoke, Professor of International Law, University of Jos, Nigeria. I must start by congratulating the presenters for doing a wonderful job. But my problem has always been a question of whether, for example, the original treaty envisaged, the 1975 treaty envisaged integration, economic integration, or cooperation. Because it appears that the 75 treaty merely emphasized cooperation. And it was in the 1995 treaty that there was a shift towards economic integration. And basically, the 1995-93 treaty tended to have deciphered the basic components of integration. And that component is commonality. There can be no integration without commonality of laws, commonality of policies, and so on and so forth. Accordingly, you must understand that the importance of community law in driving the integration process cannot be overemphasized. Like the second presenter, Professor Nabulele, has copiously pointed out, if there is no community, then there can be no integration. There are lots of emphasis by states that have purportedly undertaken treaty obligations without performing them. So when it comes to questions, we talk about free movement of goods and persons. And yet, at the point of entry, including when we were coming here, there were lots of policies that were predicated on sovereignty, that were imposed on us as purported community citizens. I am using that word, purported community citizens, because if I am a community citizen, then I should be in a position, for example, to approach the community court to enforce my right at home. I remember at a time when Nigeria closed its borders, there would have been possibly the development of community law, where an individual from Ghana or even from Nigeria who has been affected by the policy of Nigeria, having undertaken to be a member of ECOWAS, to have gone to court to challenge that policy and possibly get a judgment that he will be in a position to enforce against Nigeria. But when these precepts are not there, we cannot talk about community. And then moving, I think the problem is a confusion of supranationality and integration, just like the previous speaker pointed out. Supranationality exists where there are three basic components. One, the existence of a treaty. Secondly, the creation of what I will say an autonomous body to which some measure of sovereignty has been ceded to act on behalf of the integrating components of that particular integration model. In this case, an ECOWAS commission was created without the powers of acting on behalf of the integrated states. And then, thirdly, if you still have a lot of impediments existing in our municipal laws, then you cannot get to the level of supranationality. Now, in our institutions, can we say there is a community law? Of course not. Even at a time, ECOWAS took one step forward and 3 steps backwards. You first of all allowed some kind of direct application of the treaty, the protocols, and so on and so forth. The direct application in the legal systems of member states. Then what you gave with one hand, you took it again with another in 2010 by saying, no, there will be no more direct application. It is now a question of who would try as much as possible to take steps to make sure that our laws are brought in consonance with the obligations that we have undertaken. So the community is vacillating. Let me use that word, community in quotes. It's vacillating between intergovernmentalism and a purported supranationality. And that is what the problem is. Even the money states, my little experience in the court between 2014 and 2018 suggests, even the money states, the purported money states, still comes before your court and argue the supremacy of their constitutional law over the ECOWAS treaty. So what are we talking about? And that is exactly from Benin to Sierra Leone to Nigeria to Cote d'Ivoire, that has always been their arguments. That unless our constitutional law is amended, whose obligation is it to amend? The states. And none has taken any steps in that regard. But if we had had an actual community, a community that benefits individuals, not just states, what we still have is an intergovernmental community. And that's why I also agree with Professor Bubra that we still practice intergovernmentalism in the guise of supranationality, where the basic legal instruments to ensure the smooth operation of the principles of supranationality does not exist. The mere existence of law, legal instruments, does not ensure the existence of a particular model.
And that is why, of course, those of us, I will always emphasize, that read the Holy Book say, it is the letter killeth. It is the spirit that giveth life. Thank you very much.
Right. I just realized that I'm moderating a session between lawyers, academics, and judges. Each of these is an unstoppable group of people, so I'm going to impose some supranational rules. When you are making a comment from the floor, you don't speak for more than 3 minutes. You may come again in my discretion, and I'll enforce the law. So, my brother to my right.
Merci, Monsieur le Président. Alors, je m'appelle Alioune Sall, je suis du Sénégal. Je suis ancien juge à la Cour de la CEDEAO. Je suis professeur également et je suis membre actuellement de la Commission du droit international des Nations Unies. Bien, je voudrais très rapidement faire quelques observations sur les choses qui ont été dites et peut-être essayer d'apporter une contribution. L'esprit général de cette contribution, c'est peut-être d'inviter à une forme de comment dirais-je, de conciliation des points de vue. Parce que je pense que les questions qui ont été évoquées, qui ont été soulevées, ne peuvent pas nécessairement faire l'objet de réponses de principe qui soient fermes et péremptoires. Aussi bien sur la question de l'existence ou non d'une intégration dans le cadre de la CEDEAO que sur la question du modèle que nous aurions ou que nous n'aurions pas. Je crois que sur ces deux questions, il faudrait peut-être adopter des réponses nuancées et des réponses modérées. Et pas nécessairement des réponses absolues ou péremptoires. Sur la question d'abord de l'intégration, il me semble d'un côté qu'il est incontestable que la CEDEAO a adopté un modèle d'intégration et l'a traduit en acte. En acte. Si vous prenez le traité de 1993, vous y verrez des choses inédites qu'on ne trouve pas dans le traité de 1975. Vous y verrez par exemple que la CEDEAO a un pouvoir normatif contraignant qui oblige les États membres. Ça n'existe pas dans le traité de 1975. Vous verrez que même la condition de l'organe intégré, qui est aujourd'hui la Commission, on a dit que la Commission ne servait à rien. Je ne suis pas très sûr. Comparez la situation de la Commission actuelle avec la situation du secrétariat exécutif de 1975. Vous verrez que ce n'est pas tout à fait la même chose. D'abord, il y a une professionnalisation de la fonction, et ensuite, il y a l'accroissement des garanties statutaires pour les commissaires qu'on ne trouve pas pour le secrétaire exécutif. Je m'en tiens juste à cela. Je ne parle pas de l'extension du champ matériel de la compétence de la CEDEAO, qui a investi des domaines qui étaient inconnus du traité de 1975. Et donc, de ce point de vue, je pense qu'on ne peut pas nier qu'il y ait eu avancées. Maintenant, est-ce qu'il n'y a eu que des avancées? La réponse est non. C'est pour ça que j'ai parlé de la nécessité d'avoir une approche modérée, nuancée. Pourquoi? Parce qu'à côté de ça, il y a des sujets de préoccupation qui montrent que l'intégration n'est pas parfaite. Je donne un exemple. Il est prévu, dans le cadre du traité de 1993, qu'il y aurait des matières sur lesquelles on devrait décider de manière majoritaire, ce qui est le signe le plus évident de l'intégration. Or, ce protocole n'a pas eu lieu jusqu'à présent. Il n'a pas été pris. De sorte que, même si nous vivons théoriquement sous l'empire d'un système d'intégration, nous continuons à appliquer des méthodes interétatiques parce que de fait, les décisions sont prises à travers une unanimité de fait, c'est-à-dire à travers ce qu'on appelle le consensus. Ça, c'est un problème. Je prends la question de la monnaie unique. La question de la monnaie unique dans la CEDEAO, on en parle depuis 1980. Il n'y a pas grand-chose vraiment qui a été fait depuis. Vous avez parlé tout à l'heure de la fermeture des frontières. Essayons de relier ça à la problématique plus générale du droit de circulation. C'est un évident. Nous avons tous fait l'expérience, nous, individuellement, des limites de la liberté de circulation dans l'espace CEDEAO. Voilà un certain nombre de sujets sur lesquels, incontestablement, l'intégration tarde à se faire. Et donc, je pense que sur cette question précise, il faut apporter des réponses nuancées. Nous sommes en principe dans un système d'intégration. Nous n'y sommes pas tout à fait en fait et parfois en droit. Voilà le premier point que je voulais soulever. Le deuxième et dernier point, c'est sur la question du modèle d'intégration. Est-ce qu'il y a un modèle? Et c'est la question du mimétisme au fond qui est posée. Est-ce que la CEDEAO a inventé un modèle? Je pense qu'elle ne peut pas tout à fait inventer un modèle. Pourquoi? Parce qu'il y a des problèmes que toutes les entreprises d'intégration dans le monde sont obligées de traiter de la même façon. Ce sont des problèmes qu'on trouve dans le système européen, ce sont des problèmes qu'on trouve dans le système du Mercosur en Amérique latine, ce sont des problèmes qu'on trouve à l'ALENA. Il y a des questions structurelles, transversales, que toute entreprise d'intégration est obligée de traiter. Et la CEDEAO, sur ces questions-là, ne peut pas faire par définition preuve d'originalité. Voilà pourquoi il faut faire un peu attention à cette quête forcenée d'autonomie. Il y a des questions sur lesquelles on ne peut pas être autonome. En revanche, il y a des questions sur lesquelles on peut être autonome. Lesquelles? Par exemple, je pense que sur la question de la définition des actes susceptibles d'être pris par les organes de la CEDEAO, je regrette le manque d'originalité de la CEDEAO. L'acte additionnel de 2010 qui dresse la liste des actes est une copie conforme du traité européen de 1957. On a recopié jusqu'à la phrase. C'est d'autant plus regrettable que vous observez le même phénomène ailleurs qu'en Afrique de l'Ouest. Si vous allez en Afrique centrale avec la CEMAC, c'est la même chose. On a été saisi d'une sorte de paresse intellectuelle que moi je regrette beaucoup, qui a consisté à aller recopier systématiquement à la virgule près les dispositions du traité européen. Je pense que ce n'était pas nécessaire, même si l'Europe pouvait nous inspirer sur d'autres questions. Je voudrais finir sur une note un peu plus optimiste. C'est qu'il est arrivé tout de même, dans cet océan de critiques que la CEDEAO peut recevoir, que celle-ci ait fait preuve d'originalité. Je prends juste un exemple, c'est la question de la citoyenneté communautaire. C'est une question qui tend à être banalisée, mais la citoyenneté communautaire, c'est la CEDEAO qui l'a inventée avant l'Europe. Elle l'a inventée avant l'Europe. Les Européens parlent de citoyenneté communautaire depuis 1992, c'est avec le traité de Maastricht qu'ils le disent, quand ils ont fini leur marché commun et qu'ils ont entamé la phase politique de leur intégration. Mais nous, en Afrique de l'Ouest, c'est 10 ans avant qu'on a parlé de citoyenneté. Le protocole de 82 sur la citoyenneté communautaire précède de 10 ans le traité de Maastricht. Malheureusement, le contenu qu'on a conféré à la notion de citoyenneté est un contenu relativement pauvre. Mais le concept lui-même, il est né en Afrique de l'Ouest 10 ans avant de naître en Europe. Voilà quelques observations que je souhaitais faire, juste pour inviter à une forme de modération dans l'appréciation que l'on peut porter sur ces questions. Je vous remercie.
Very much. Thank you. Thank you. To my left, let's begin with Professor Abuchi in the middle, and then we'll go to my brother there and come to my brother sitting right opposite me. Give him the microphone. And then I'll come to you, sir. Okay.
Thank you very much, my Lord Moderator. I think that it's also perhaps important to recognize the fact that this is an evolutionary
Professor Abuchi.
This is an evolutionary process. ECOWAS, like the EU itself, the EU itself hasn't even achieved optimality yet. The EU is evolving, and ECOWAS is far behind, but it is still evolving nonetheless. Aside, for example, the practical example of Hungary and Poland, who have been seen as errant boys of the EU, and are constantly in breach of EU regulations, and have, in certain circumstances, even refused to enforce decisions of the ECJ. The reality is that supranationality is an exercise in external accountability, an exercise in ensuring that the membership of the group are accountable to each other, and through the collectivity, they ensure that they achieve certain goals. Now, in this regard, for countries that are used to being very happy, calling themselves sovereign, once they are being boxed in an arrangement that compels them to account to others, they will invariably, when it suits them, either breach the rules of the supranationality or, as it were, recoil. I think the truth of the matter, and one of the speakers, respectfully I forgot, but one of them mentioned the fact that ECOWAS was formed by largely military leaders. So the founding philosophy and the founding background of ECOWAS colors not only the structure, but also the values of the entity. I do not think that we have to go back to 1975. Nor do I think that we even have to go back to the 2000s when revisions were done. I think that we have to just accept what I would perhaps call the creeping supranationalization of ECOWAS. There's a gradual creeping process where ECOWAS appears to be metamorphosing itself, and it's recognized the difficulty of going back and, as it were, gathering heads of states who, in reality, have no incentive to cut back on their powers. And so, while I accept the difficulties that we're mentioning, this is not peculiar to ECOWAS. The EU must have been far advanced compared to ECOWAS, but ECOWAS has come a long way. And I think that with these difficulties, we should just find ways of mopping up. And the distinction between supranationalism and intergovernmentalism, that distinction at a certain level still remains artificial. Even though, in truth, I accept the difference. The difference is one is more compact, the other is more clearly delineated. But even at a certain level, sometimes you can't see that distinction. It's blended. And so I am very much excited about the conversation, but I would hope that we also be a bit nuanced in our conversation so that we have things clearly stated. Thank you.
Thank you. To my brother on the left. Oh, okay, you have the microphone already. Please, sir. It's my brother in the middle, then to you. Yeah. Please, sir.
Merci de me donner la parole. Je suis au tribunal de première instance d'Abidjan. Je me permets de parler à la suite des éminents enseignants. Moi, je voudrais juste poser une question. Je remercie déjà les intervenants d'avoir touché du doigt le principe de l'application directe des traités. Je voudrais juste leur demander, parce que ce problème se pose au sein de la CEDEAO, alors que ces mêmes États qui, par exemple, au sein d'une organisation comme l'OADA ou même l'UEMOA, ont accepté le principe de l'application directe, parce que les normes de l'UEMOA, les règlements, les directives s'appliquent directement dans les États sans passer par une ratification au Parlement. Il en est de même pour l'OADA, les actes uniformes, parce que le traité même de l'OADA, en son article 10, c'est très clair. Il dit que les actes uniformes sont directement applicables, nonobstant toute disposition nationale contraire ou postérieure ou antérieure. Ça veut dire que là où un domaine où l'OADA, le Conseil des ministres, a pris une décision, aucun État membre ne peut prendre une loi dans ce même domaine. Ces mêmes États-là sont membres de la CEDEAO, en dehors des États de l'Afrique centrale, bien sûr, membres de l'OADA. Mais je veux dire que la plupart des États de l'Afrique de l'Ouest, membres de l'UEMOA et de l'OADA, ont accepté ce principe-là. Mais quelle est la difficulté pour que ce même principe ne soit pas accepté au niveau de la CEDEAO? C'était là ma question. Parce que quand on lit les thèmes du traité de la CEDEAO, on voit les États s'engagent, les États conviennent, alors que le traité de l'OADA et le traité de l'UEMOA, c'est des obligations.
Thank you. My brother on the left. He's right behind you, ma'am. And then sir will come to you.
Thank you very much, my lord. My name is Yusuf Danmadami. I'm a staff of the ECOWAS Court. Firstly, I would like to thank the presenters for their very brilliant expose. I've listened carefully to the debate, and I just want to share my concerns. Firstly, I think basically we will agree that yes, indeed, that there is a progression towards supranationality in the ECOWAS. And this can be clearly seen even in judgments of the court. We may look at it from a different point of view, be it theory or academics, but I think legally there is a progression towards supranationality. And why do I say this? Firstly, I think most of the debates here dealing with whether or not we're moving towards supranationality, the legal basis has always been whether member states will ratify ratification and domestication, which is a legal valid question. But going beyond that, and I'll give you two instances, I think, yes, when you are progressing towards supranationality, then it's right that you have ceded part of your sovereignty. And I think this was clearly stated in the case of Musa Sidikan of the courts versus the Republic of Gambia, where the Republic of Gambia stated expressly that they had not ratified or domesticated the revised treaty. But the court made a pronouncement that because they are members of the ECOWAS, they have ceded part of their sovereignty to the Commonwealth, the common benefit of ECOWAS, and they went ahead to actually give judgment against the Republic of the Gambia. This also happened in the case of Valentine Aika versus the Republic of Liberia. And surprisingly, even when Liberia refused to, Liberia went ahead to enforce the judgment of the ECOWAS Court of Justice. So in all of this, what I'm saying is that, yes, there is a progression towards supranationality in the community, even from where we see it from the legal perspective. And I give another example, for example, the Republic of Ghana. Yes, being a dualist state, based on the Ghanaian constitution, Section 75 provides that, a judge cannot, of course, enforce any agreement or any treaty, one that has not been domesticated or enforced. But surprisingly, the Supreme Court of Ghana, in the case of, I think, was it Delma's American-African Company, actually used Articles 18 of the Vienna Convention, which also stops any country from using its domestic law, not to, implement its foreign obligation, to hold Ghana responsible when it was very clear that Ghana had not yet ratified or domesticated, the treaty at the time. So I just want to join my voice with other distinguished presenters that indeed there's a progression from intergovernmental affairs to one of that of supranationality in the ECOWAS. Thank you very much.
Thank you. Now to my... You have the floor.
Merci, monsieur le modérateur. Moi, je viens du Togo, je ne suis pas professeur de droit, fonctionnaire de la Cour, je suis avocat et je vais partir d'un certain nombre d'observations en tant que citoyen de la CEDEAO. Je voudrais d'abord exprimer ma joie d'appartenir à la CEDEAO et de me féliciter de ce modèle d'intégration qui est en marche. Parce que quand vous quittez le Gabon pour aller au Cameroun, vous êtes soumis à une demande de visa. Par contre, quand vous quittez le Togo pour venir au Sénégal, au Mali, au Niger, votre carte d'identité ou votre passeport suffit à vous faire passer. C'est déjà une grande avancée. Sauf que lorsque vous quittez le Togo pour aller à Accra, d'abord les demandes qu'on vous impose à la frontière et les arrêts que vous suivissez jusqu'à arriver à Accra posent problème sur la notion de la libre circulation des personnes et des biens. Donc l'intégration est en marche. La Cour de la CEDEAO est un motif de satisfaction pour les citoyens de notre sous-région. On s'en réjouit. Moi qui ai l'habitude de faire d'autres juridictions, je peux témoigner que la Cour de la CEDEAO est une réussite. Sauf que la volonté politique sur certaines questions manque. On en parlera au cours de cette session, parce que je me souviens quand j'allais devant la Cour, le nombre de magistrats était 7. On a réduit cela. Donc je crois qu'il faut aborder cette question-là sur deux aspects. La volonté politique d'aller loin. Quand on est au pouvoir, d'aller loin et de respecter les engagements que nous avons pris en adhérant, en signant le traité de la CEDEAO. Deuxièmement, est-ce que les peuples sont suffisamment outillés et informés sur la nécessité de se sentir membre de cette communauté? Et la troisième chose, c'est de considérer que sur un certain nombre de sujets, nous pouvons faire mieux sur les questions douanières, les questions de la libre circulation des personnes et des biens, les principes de démocratie, de bonne gouvernance et des droits de l'homme, des traités, des recommandations ont été prises mais qui ne sont pas respectés par l'ensemble des États. Maintenant, tout ceci dit, le constat est fait que nous sommes dans un modèle d'intégration qui est à améliorer. Mais au sortir de Praia, qu'est-ce que nous allons offrir aux gouvernants? Qu'est-ce que nous allons leur demander? Qu'est-ce que nos sociétés civiles peuvent porter comme message pour changer les mentalités et aller au-delà de ce que nous vivons? C'est le débat. Parce que si nous sommes présentés, nous sommes arrivés jusqu'à Praia, c'est de faire en sorte que lorsque je prends ma voiture de Lagos jusqu'à Dakar, que sauf pour des motifs liés au terrorisme et à l'insécurité, que je ne puisse pas faire l'objet de tracasseries tout le long de ce chemin. Lorsque mes droits sont violés au Togo, par exemple, que je puisse avoir des répondants au Mali, au Niger, qui puissent me soutenir devant la cour de la CEDEAO. Quelle est la feuille de route que nous allons maintenant donner à nos gouvernants, à la Commission et à la Cour pour rendre réelle et concrète l'intégration? C'est la question que nous devons nous poser. Et ce que nous pouvons faire, c'est qu'aujourd'hui, nous nous sommes réunis ici en tant que juristes, en tant que spécialistes, en tant que tout et tout. Mais il faut associer des organisations de la société civile qui sont plus proches des peuples pour relancer le débat sur la compréhension du traité de la CEDEAO et surtout faire du lobbying, du monitoring pour que la Cour reprenne ses droits. Ce sont ces choses-là qui sont importantes. Parce que tant qu'on ne se sera pas libre de circuler librement, de nous porter, d'être concernés par la richesse du Nigeria ou la richesse de la Côte d'Ivoire, l'intégration est bancale. Elle demeure sur un pied et ce n'est pas normal. J'ai dit, je vous remercie.
Thank you very much. Thank you. Madam, please, right here. Brother, anyone else? And then I see another hand to my left. And then, so from up there, you come down this way. Please, sir.
My Lord, I'd like to very much thank the presenters for their very excellent presentations and the various interventions. I struggled to resist the temptation to speak, but I couldn't, so I'm sorry. I think something, and I've said this previously in another meeting, I think sometimes we have this pressure, this thing to protect ECOWAS. Like, we need to protect ECOWAS. I don't think the question is whether ECOWAS is good or bad.
Can I do this?
Yes, sir.
If you don't mind, I'll have you resume your seat. Let's take the comments. Because you gave the keynote, I will give you 5 minutes when I give each of them an opportunity to respond. I want to give you preferential treatment. So,
Thank you very much.
So we take it down to my brother to my left. Yeah? Please, show your hand so she can give you the microphone. Yes. And then, madam, there's a hand up here.
Merci beaucoup, Monsieur le Président. Je suis Armand Sonton, je suis le directeur de l'intégration économique régionale au Bénin. Je voudrais d'abord remercier les panélistes pour la présente présentation et indiquer que à chaque réunion, c'est toujours les mêmes problèmes qui se posent. CEDEAO, ça a évolué, ça n'a pas évolué. Mais je voudrais souhaiter qu'on intervienne surtout pourquoi ça n'a pas évolué. Qu'on s'interroge sur le pourquoi. Vous savez, moi, j'ai la chance de participer à plusieurs réunions de l'UOMOA et de la CEDEAO. Mais vous allez constater qu'au niveau de l'UOMOA, ça marche un peu mieux. Pourquoi ça marche? L'UOMOA a mis en place un système de suivi, d'évaluation permanente. Au niveau des actes communautaires, au niveau de l'UOMOA, chaque année, il y a une évaluation au niveau de tous les pays. Et il y a un rapport annuel qui est sorti. Et quand une directive pose problème, les États membres s'assiedent, discutent et font la relecture. Vous allez constater qu'au niveau de la CEDEAO, il n'y a pas cette pratique. Une fois que le test est pris, c'est fini. Pour moi, ce n'est pas suffisant. Nous devons mettre en place un système d'évaluation, voir ce qui a marché, dans le temps, les évolutions que notre espace a connues. Est-ce que le test n'a pas besoin d'être amélioré? Est-ce que le test n'a pas besoin d'être revisité? Mais on ne le fait pas au niveau de la CEDEAO. Il n'y a aucun suivi. Au niveau de la circulation, les chefs d'État se sont réunis plusieurs fois, ouvrir les frontières. Jusqu'à aujourd'hui, il y a des frontières qui sont fermées. Qu'est-ce que la CEDEAO a pu faire? C'est les véritables problèmes qui se posent au niveau de la CEDEAO. La CEDEAO est une grande institution, mais je note que vraiment, malheureusement, qu'il n'y a pas le suivi. Je pense que sans suivi, ça ne marchera pas. Les États membres, c'est des hommes qui sont là. Il faut les secouer un peu, il faut les déranger un peu, il faut qu'ils sentent que quelqu'un est derrière eux. Mais sans ce mécanisme, on va beau parler, on va beau faire des réunions, mais ça ne marchera pas. Moi, je voudrais faire des conditions faites à la CEDEAO pour dire qu'il faut qu'il y ait un système d'évaluation. Les pays qui font bien, il faut qu'ils soient encouragés. Les pays qui font moins bien, il faut les inviter à aller de l'avant. Et surtout, instaurer un système de justice. La CEDEAO, il n'y a pas la justice. Il n'y a pas l'équité. C'est celui qui est fort qui gagne. Non. On est entré dans la CEDEAO en tant que pays et je pense que les choses doivent être faites de façon équitable. Si on ne le fait pas, ça ne marchera pas. S'il y a des tests, des actes, des protocoles, si un pays ne veut pas appliquer, ça ne donne pas. La question de la monnaie unique, jusqu'à aujourd'hui, ça n'a pas évolué. Pourquoi ça n'a pas évolué? Pourquoi ça n'a pas évolué jusqu'à aujourd'hui? Je pense que c'est des questions phares sur lesquelles je souhaiterais que vraiment les professeurs réfléchissent à ces questions-là, qu'on trouve une issue heureuse pour que la CEDEAO puisse avancer. Merci beaucoup.
Thank you. Right. Left.
Thank you, my Lord, Honorable Moderator. I want to begin by commending us for their. I want to hear towards this issue of supranationalism. First took a very important action by amending the protocol of the Treaty of the Community when they amended the 1993 revised treaty, Article 9 to be specific, to provide for a new legal regime. And in that amendment, it was stated specifically that the community will no longer adopt protocols, rather that they will now adopt supplementary acts. And that the supplementary acts, the decisions of the authority, regulations, all of them will be directly applicable in member states. That was a very bold move, but 4 years later in 2010, it was clawed back because that decision was reversed and only regulations were now directly applicable, which in practice is equally very doubtful. So these are the issues. It is easy to adopt these regulations, protocols, or international agreements, but they are never domesticated. They are never ratified. And just as Honorable Justice Moki spoke about commonality, if you don't have a supranational organization that can regulate and enforce decisions member states have taken, and we are leaving it completely at the hands of member states, we will not move. At the last conference, somebody spoke, I think, from Ebobra, that having a legal regime is not the same thing as having a legal order. We have a legal regime because we have adopted so many treaties, but we don't implement them. There's no legal order because even Article 57 of the treaty that speaks about the harmonization of the legal and judicial systems of the community has not been done. Member states will assume responsibility at the community level, but they don't want to be held accountable for those, for those responsibilities they've assumed. They even come before the ECOWAS Court of Justice to rely on their own failure to implement, to domesticate as an excuse to escape from the responsibility they have assumed. So it is important for us to dwell, why did they reverse themselves? important decision was taken because now the treaties and supplementary acts are not directly applicable. The ones that they've adopted, they don't domesticate, they don't ratify. We are in limbo. So something needs to be done. Either we intend to actually, so as Nabulele said, do we have a community? Let's start from there. Do we really have a community? Because not enough to adopt when you are not ready to implement, you are not ready to enforce, you are not ready to ratify, you are not ready to domesticate, you are not ready to even implement or enforce your own obligations you have assumed. And you don't have a supranational organization that can enforce it, that can monitor your implementation of these things. So there's a problem that we really need to look into. Thank you very much.
Thank you. You don't always get to regulate the register of a supranational court, so your time is up. Any more questions? Otherwise, any comments? Okay, so let me proceed first with Professor Agent Provocateur. You called out the elephant in the room, so I think you should make your comment now, and then we'll have our presenters speak to the myriad of issues that have been raised.
Thank you, my Lord. So I was saying that sometimes I think we feel a pressure to protect ECOWAS. But my understanding is that when we come for these programs, what we are doing is not a normative assessment of ECOWAS. What we are trying to do is understand where we are, so that when we talk about in fact, I was wondering if Professor Nabulele read my paper. I cited someone who says it is possible to integrate an intergovernmental model. So, are we really doing integration in a supranational manner? That is the critical question that I think we are interrogating. But linked to that is the other question. Do you only have an obligation as a member state to comply with your whatever it is you have taken on, so your treaty obligations, does that obligation only arise when you put the tag supranationality? And we are saying that's not the case. But it's an important distinction, Prof. It's an important distinction, because if my president and every other president sits down here, assuming that this is where they adopt the question is, are they the lawmakers in the national systems? They are not. Do they have the executive prerogative to override constitutions? They do not. Which is the reason why, if you look at what has happened in Europe, each state goes back to ask its citizens, do we want to do this? There's a referendum. There's engagement with the constitutional process. Then it is possible for your law at the community level to go directly into the national system and create rights and obligations for citizens, no longer for states. That is supranationality. But if you decide that you do not want to go that model, then the state takes on responsibility at international law, which is when the Vienna Convention on the Law of Treaties comes to say you cannot invoke your national law. So your responsibility is at the level of international law. That is intergovernmental. Your responsibility is not within the national legal system. So it's important that we know exactly what we want to do and what we are doing. Where have we reached? And as I said in my keynote paper, it's a process. So no one is saying that this must happen today. I mean, European integration began in 1950-something. For a very long time, several years, they did not get, even till today, there are still areas, as someone pointed out, where things are not exactly the way they should be. So no one is saying ECOWAS has done badly,
We're saying we need to know exactly where we stand. But we also need to acknowledge the fact that the mere branding, if you like, in fact, what I want to say is that you cannot legislate supranationality by fiat. It's something that involves engagement at the national level. It is not the prerogative of any head of state to overrule their constitution at ECOWAS meetings and then come back and say, hey, Chief Judge, you must implement. It doesn't work that way. So I thought that we should make that small clarifications. The other issues, I'm sure you'll find in our respective papers, and the conversations becomes very robust. Thank you, my lord.
Prof, thank you. Thank you. Thanks for the clarity. So now you started, so you go this time. Microphone. Okay, so I'll give you this one. Yes, you can go back to where you were since you're more comfortable standing. I have 5 minutes.
Okay, thank you for your responses. Just a few, not a few, let me just see how far I can go. Professor Sarr mentioned something about citizenship. And I'm not too sure if actually ECOWAS citizenship conception predates that of the EU, so I'm not going to respond to that. But in the 1975 treaty, there was a definition of citizenship that was wide enough, good enough for everyone, until that was tinkered with in 1981 or so. I'm not sure it was 1990. And they brought in the issue of dual nationality, which in itself is a problem. So that, I'll just leave that aside. Then cooperation. The fact that an international instrument uses cooperation. I said in my paper, it appears I anticipated this, and I said, I'll just read, why I take no issue with the view of some writers who seek to differentiate cooperation from integration. I would like to state that the use of cooperation is not a term of art. It does not constitute a defining factor, thus necessitating the need to look at the intention of the organization beyond the use of the word cooperation. 1975, you had the word cooperation, economic cooperation, but also if you go deep, you see the provisions going towards free trade area, customs. You know, I hope I'm right, but I know I've seen that. Then you see a provision on citizenship. So all of this, when you look at all of this, it goes beyond cooperation. There was actually an intention, to integrate economically. I thought I should make that clear. Then, judgment of domestication of treaty. Yes, I think it was the gentleman over there, forgotten his name, that talked about a case that was decided in Ghana, and you were talking about Article 27 of the Vienna Convention on the Law of Treaties that says that, is this mic on? Yeah, a state cannot plead its municipal law to defeat its international obligation. Now, and you mentioned ECOWAS court decisions. There's a distinction that we need to understand. ECOWAS court is an organ of ECOWAS. It's an organ of international law. Municipal courts are organs of municipal law. We don't have, that's why that also goes to the issue of having a community. It's an organ of municipal law. So for ECOWAS courts, whether you have domesticated anything or not, it doesn't affect the decision of ECOWAS court because it's an organ of international law. So you cannot go before ECOWAS court and say, oh, we have not domesticated, so it cannot apply to us. Article 27 says, no, you cannot do that. But if you go before a municipal court, is an organ of municipal law. It's going to be looking at the Constitution. Just, okay, what does the Constitution say? And it's the Constitution that he will apply or she will apply. However, it doesn't stop the court, for instance, from drawing from the jurisprudence of the ECOWAS court. And in the common law system, where you have a judicial precedent, a court can draw, like the Supreme Court can draw from jurisprudence of ECOWAS court, and it becomes the general law because of the issue of precedent. It's not the provision itself, the treaty that is becoming part of Nigerian law, but the jurisprudence of the court. So there's that difference that we need to always pay attention to. And again, also on the judgment of the court, you see, that also goes to show the issue of community. If we have a community, for instance, I'm not saying if the communities, let me actually make this point. I'm not saying that ECOWAS, that's what I'm calling myself, there's no community or there's no integration, I'm saying that ECOWAS has made attempts. So let's get that clear so that we don't think that, go away to say, oh, nothing has happened in ECOWAS. No, ECOWAS at least, it's advancing, it's progressing, but it hasn't got to that point. And we need to achieve one point before we begin to move to the other. We can't just take it to say, okay, it's not advocacy, it's beyond advocacy, way beyond advocacy. Now, if we're dealing in a consummate community, for instance, ECOWAS, it would be an anomaly to say that ECOWAS court decision is self-executing or having direct effect. ECOWAS court decision within ECOWAS community is a community decision. So it should apply. Because when you begin to do that, if I just digress a little, the International Court of Justice, for instance, there's a case, I think, Avena and 50 Mexican national, I'm very close. Yeah, 50 Mexican nationals, where a decision was given against the United States. The United States did not implement. They went back to the ECOWAS court, to the ICJ, and the ICJ said, well, yes, we've given that decision. United States did not implement because the Supreme Court said this decision is not self-executing. He said, well, there's nothing we can do. Go back. What we're saying is that it is for the state to take steps to execute this decision because it's not self-executing. But in ECOWAS, you cannot begin to say that because the moment you say that, you're admitting that actually there's no community that we have created for these laws that we call ECOWAS law. Okay. Why have things not improved? I like the point about evaluation, because that is actually what we're trying to do. We're doing it in this conference. ECOWAS needs to actually evaluate what happens within member states. Where is this member state? As far as ECOWAS laws and treaties are concerned, why have things not moved forward? Things have not moved forward because the states have not themselves moved forward. Look at ECOWAS. There's always the problem of shifting deadlines. You have shifted deadlines. But before you blame ECOWAS, go to the states. How many states have met their own developmental deadlines? Not many, if there's any. So they let's say that it's okay, 2020, Vision 2020, before 2020, Vision 50, like that. So if they can't achieve it, get it right at municipal level, the same people, are they going to come and get it right? You can't build something on nothing. So why we have not moved forward is because the states themselves have not also moved forward. The states need to begin, that's what ECOWAS need to do a bit of that evaluation that somebody spoke about. Go back and do the evaluation, see what is happening within the municipal level of states. It is not enough for heads of state to come to Assembly of Heads of State and Government and say all the nice things, or come to a conference like this, tell us all the nice things, but when it comes to the actual thing to be done, it's not being done. Should I think I'm happy to. Thank you.
Lily deserves a clap. Thank you. Thank you very much. Prof. Ladders, 5 minutes, please.
I decided to stand this time around. Mr. Moderator, this panel is required by the organizers to answer the following questions. Number one, does ECOWAS have an integration model? In my view, ECOWAS has an integration model from 1975 treaty to the revised ECOWAS Treaty of 1993, through the supplementary acts up to 2010, clearly demonstrates that ECOWAS has an integration model, an economic integration model, which starts from economic cooperation to move to the next stage, which is free trade area, where ECOWAS as at now is about 40-45%, fine-tuning the free trade area agreement, and that's where we have a lot of homework to do before it can move to customs union, even though as at last month, the customs union have actually, because they have been pushed by the Continental African Trade Area Agreement, after They have accelerated their effort in ECOWAS, just like in other RECs, in order to meet up the Continental Customs Union agreement. So they have accelerated their effort, and we are almost 45-50% on Customs Union in terms of the packaging to address all the barriers in the ECOWAS sub-region. This is actually truly on ground. So we need to perfect that Customs Union as the third stage of our integration model, Mr. Moderator, and the fourth stage of our integration model, which is in all these laws from 75 to the Supplementary Act of 2010, that we move from Customs Union to market integration. And from market integration, we now finally arrive at monetary integration, as the last stage. That will complete the economic integration model of ECOWAS in 5 stages. So this is actually the first point that I want to draw attention to. Number 2, 3 of our colleagues from Guinea and I think Togo made mention of why are we not making progress in ECOWAS, and progress is being made in UEMA and in OHADA. This brings me to the second point. There is the legal integration model component, because you cannot achieve economic integration without the legal integration component. And the legal integration component anywhere in the world, has two phases. Phase 1 is either you move towards uniformity of laws, uniformity of commercial laws, business laws, corporate laws, company laws, and any other law in that, trade, investment, competition. That is one component of the legal integration model. Or you move towards harmonization of laws and policies and regulations in your sub-region. And this will actually be harmonization of your trade, investment, competition, company, corporate, laws. That is actually, so where does ECOWAS stand on the legal integration component from 75 to date? I can tell you, because ECOWAS actually is having 3 legal systems, 3 linguistic issues, and 3 also juridical jurisdictions in operation, which is actually in practice and a practical reality you cannot run away from. ECOWAS decided to actually not to adopt the OHADA system, and it also decided not to adopt the UEMA system, even though our colleagues from the Francophone did mention the progress being made in UEMA and OHADA. And the reason why they are making progress is because they are all Francophone countries. So it's easier for them within their civil system to move towards uniformity of laws in OHADA, uniformity of laws in UEMA, whether in market integration or in terms of business laws. I have studied in the last 15 years, and I've been part of the engagement whether we can harmonize ECOWAS model law on uniformity of laws with that of UEMA and OHADA. And I've participated in all the meetings in the last 15 years, so I know where we are. And the reason why we reach a deadlock is that ECOWAS can never adopt OHADA or UEMA style of legal integration. Why? Because we have the Lusophone, we have the Francophone, and we have the Anglophone, and all the legal traditions are extremely difficult, so you need to carefully balance them. So the surest way to go when you have tripartite legal system in operation and you want to harmonize their investment, trade, competition laws is not to go for uniformity, as in OHADA and UEMA, but it's to go for harmonization. I.e., you distill the common principles, and I'm, Mr. Moderator, I've participated in drafting 13 supplementary acts for ECOWAS on this point from 2006 to date. So you have to do harmonization. You distill the common principles in all the member states, and then you come up with a common framework on corporate law or on business law, on trade investment, and we have done that with the investment code and policy, and it's been adopted. And same for competition, it's been adopted. And we're making move on other areas. So ECOWAS is making the progress even on legal integration component, but choosing the phase of harmonization as opposed to uniformity. And that is my response to our colleagues from Francophone that took the floor to show that progress is being made in OHADA and in UEMA, in this context. And I beg to clearly point out that ECOWAS deliberately
chose not to adopt the uniformity approach because it will not work in ECOWAS because of differences, that we have in tripartite system. And the best way in regional economic integration to adopt a legal integration model is to go, in the circumstances of ECOWAS, is to go for harmonization. And that works perfectly in ECOWAS. And Mr. Chairman, since I gave you my 8 minutes, I want to take it back with your permission. Okay, I'll run up.
I gave you 5 minutes.
Okay, thank you very much.
You have actually done 5. I will give you 1 minute bonus.
Mr. Chairman, I'm rounding up on your behalf as our panel, and I ceded my 8 minutes. But I now needed that 8 minutes to actually respond to the question.
Professor, 1 minute.
All right, thank you. Let me also say that, first, it is true what Professor Sall said, that ECOWAS is an integration model, and we need to be optimistic. I took the floor deliberately to speak to my paper because I'm very optimistic. But I think we need to actually understand that being optimistic about the effort being made in ECOWAS does not mean that we are protecting ECOWAS. And I think I beg to disagree with Professor Solomon. We are not protecting ECOWAS. It's not a protection. It's simply recording what has been done and what we believe needs to be improved upon. And everybody is saying that something needs to be done. Let me take, actually, for instance, those of us that are professors. Our responsibility as universities and research institutes in all member states is to aggressively engage the judges, our students, the practicing lawyers, in a continuing judicial and legal education on ECOWAS community law. That's a challenge for us. Because the ECOWAS Commission is not doing its job. And I'll repeat it, and I'll say it anywhere, anytime, that ECOWAS Commission is supposed to be aggressively, promoting and giving update in member state, going around about the state of things and the challenges ahead and how member state can add value and then even take ownership, in terms of the process and the outcome. But it's not been done. So that is where we should be pushing the ECOWAS Commission and also be doing our part. And for us, as academicians and researchers, we need to also do our part within the member state by actually engaging our colleagues and also the bar and the bench in that context. And that's the way to move forward. So I don't believe that it's always about punching member state, punching ECOWAS organs, and then when we have a lot of work to do, ourselves as a constituency. Finally, Mr. Chairman, moderator, I think there is a point made by Yusuf from ECOWAS School of Justice that there is evidence of supranationality from ECOWAS decisions. That's true. I think beyond even the case he mentioned, it is very clear that the ECOWAS Court of Justice has actually developed, a fairly good jurisprudence, on the issue of supranationality. And it has actually made the point very clear that it will continue to uphold the supranationality actually, of ECOWAS, introduced by the revised treaty into its decision-making for the realization of the community integration actually objectives. That's very clear. And the court actually made it very clear in the course of its fairly developed jurisprudence on this particular issue alone. In the case of Saidi Khan, in Serap, in Mukhtar Ibrahim Aminu, in Peter David, and it tied its decision as to why it is upholding supranationality in ECOWAS to achieve economic integration objectives, to Articles 9, subsection 4, Articles 12, subsection 3, Articles 15.4 of the 1999 Revised Treaty, and also, Articles 1 to 7 of the Supplementary Protocol. And I think this is actually the trend to go. ECOWAS is doing its own part to promote economic integration, to uphold supranationality, and the question is, what are the rest of us doing? Thank you very much.
Thank you. Thank you. You'll notice, even though I said Prof had a minute to go, I allowed him to go on. So what I did was to defer my time as moderator to him. And having done that, I think that the most emotionally unwise thing to do at 3 p.m. is to hold you down and try to summarize such a provocative, informative, and exciting, intellectually stimulating conversation. Sometimes you mess up. I think we each have a summary, a synopsis of what's happened. The good news is that there's something happening. I hear some say it's not happening fast enough, and others saying, never mind, we are on course and we will get there. I think the ECOWAS story is still a good story anyway, because each of us in this room carries an ECOWAS passport. On that note, I bring this session to a close. Thank you very much for your participation. Thank you.
Hello. Thank you, Justice Leonie and panelists. Your Lordships, dear participants, our first day has just come to an end. We'll proceed to lunch, which is in the building behind this conference center. I think we can proceed. If my lords are not too tired, we can just walk in and have our lunch. From the lunch, our bus are going to be displayed to move to our hotels. We have a colleague in Dakar for those that have lost their luggage. Dakar flight is leaving 7:30 Dakar time, which is 6:30 here. Then to arrive, firstly, around 8 o'clock. So those concerned, kindly be ready to move to the airport from between 8 and 8:30 to check if your luggage has arrived. From each hotel, we'll keep the bus that will take those concerned to the airport. One protocol assistant will be in each of the bus. Tomorrow morning, our deliberation starts at 8:30. For that reason, we'll be leaving our hotels at 8 o'clock. We'll station the bus in the various hotels from 7:30, 7:45, and 8 on the dot. We shall be leaving. Enjoy your lunch. Oh, sorry, one more. Kindly come tomorrow with your data page of your passport, the boarding passes you use all the way down here, and if possible, a copy of your ticket so that accounts people can start doing the needful. Thank you very much. Have a fine lunch. See you tomorrow. Have a nice rest also this evening. Hello. Honorable judges of ECOWAS Court and the Chief Justices, the lady here will lead you to your dinner arena. She will lead you to your dinner arena. Honorable judges from Supreme Court, please follow Justice Costa and the lady in yellow. You give it, either you give it at the entrance or you leave it on your chair, please. Kindly leave the earpiece, please. Okay, if you sign for it, then you give it back at the entrance. Please. Remember to drop the earpiece. Remember to drop the earpiece. Yes. Yes, that's what I'm saying. Well, Remember to return. Thank you, sirs. Remember to return the earpiece, please.